5 are there. Grateful.
My lord, may I permit for upgradation, my lord, monthly list item number 449, my lord, to daily list, my lord, because my lord, respondent, Asansol Durgapur Development Authority acquiring petitioners private land without due process of law, and they are saying that they are acquired by process. That is the, my lord.
My lord, may I
Grateful, my lord.
mention an extension of interim order?
Extension of interim order, yes. What is your urgency besides that? Give the number. Give the number.
Lordship, I am trying for the arbitration two matters, monthly list, item number 919 and 949. So this urgency, my lord, is petition land compensation, and another one is petitioners are made an application under section 3G5 of the National Highway Act. Application has not been considered till date.
Give the numbers.
Lordship, may I be permitted to mention one matter for upgradation, which is monthly list 324. Urgency is, my lord, petitioner has made several representation for encroaching his land by the private respondent by illegal construction. So petitioner has made several representation, but no steps has been taken. Hence, this petitioner filed his petition. I'm deeply obliged.
Call the day's list, please. Item 1.
But I am for the petitioner in this matter.
But I am for the respondent in this matter.
The case of restoration, my lord. The order of dismissal is, my lord. 30 January.
Have you served? Oh, you are appealing?
On 30th January.
Within time?
No, there is some delay, my lord.
So have you filed an application?
I filed delay application also.
Let it be allowed, Mr. Raman.
Not your lordship, kindly look to, I am not objecting to that. Your lordship, kindly can 3.
Yes.
Can 3,
Yes.
para 9. Para 9. That mentioned above clearly shows that the delay of 70 days. Just now, though I have been dealing with it just now, delays in filing application for restoration order it is passed by Honorable Justice Tobo.
No.
Your lordship, kindly see paragraph 9.
No, in a very
Your order which is under challenge, your time in the restoration passed by your lordship on 30th January 2023. But para 9 says something else.
The writ petition number is also different.
no, my lord. Kindly see page 1 of the.
What about paragraph 9?
There is 2 restoration application has been filed. One is appealing Honorable Justice Vivek Chaudhary and Honorable Justice before your lordship. I think it is a typographical error, my lord.
How it can be a
You have to file a fresh application.
No, my lord, kindly see page 1, my lord. I think it is.
How will you deal with paragraph 9, sir?
I pay for deletion.
Only page, no, why only page 1? I have to deal with all the pages.
No, kindly see the PR portion, mother.
Maybe, but you see the pleading.
Not press this, come back with a fresh application.
I lordship, kindly come to page 1, my lord. Page 1, lordship, kindly.
Let him come with the
Hey,
fresh
Dana, এটা
application.
কেন এরা
হবে কেন?
করছো?
Yes, so you asked me to ignore the paragraph 9? I have to go through the entire application?
I have entered application. I pay for deletion of this paragraph.
Page 1 is contradictory to paragraph 9?
Yes, that is true, mother. But lordship, can you come to
So if
page
that is true, why are you wasting further time, sir? Please come back with a fresh application.
paragraph 5, lordship, for a moment, mother. Paragraph 5 of this application.
I will not allow the application in the
Mother,
present form.
only for paragraph 5, mother.
We are only wasting the time of the court, sir.
I have correctly kindly named the paragraph 5. I explained, mother.
How can you correct an entire paragraph? You have stated Justice Chakraborty, WP number, writ petition
is
number,
true, mother.
something else.
By
The
mistake.
parties are others, not these
Paragraph
these
5,
people.
mother. For a moment, paragraph 5.
See, what will you do with paragraph 9? I have seen the other paragraphs.
I pay for deletion of this paragraph, mother.
How can it?
Remember,
You have to
we may be
make a
candid
fresh
to
application.
delete this paragraph. Only for technical ground, mother.
How
Let it be deleted.
I am
Let this paragraph be deleted.
এটা বলো না সে।
Can 3 of 2023.
আন্দামানের মাস্টার এত বড় বড় মামলা
আর আমার বুঝছে না ব্যাপার।
On prayer of the
কেন এরকম করছো?
applicant.
এতদিন বাদ।
করলে
applicants,
এত বড় লইয়ে
liberty is granted to delete paragraph 9 of the application. Paragraph, good grounds being shown, comma, the delay in filing the continuation application is delay in filing the restoration application is condoned. The restoration paragraph, the restoration application is taken on board. Paragraph can 3 of 2023 is disposed of. Can 2. This is an application for restoration of the writ petition which was dismissed for default by an order passed on 30th January 2023. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 30th January 2023 is set aside. Paragraph, the writ petition is restored to its original file and number. Paragraph, can such and such is disposed of. What about the writ petition? Can we deal with it now?
No.
It is not.
You need instructions? Paragraph,
That's
WPA
only I
order.
haven't given it.
Learned counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 14 July.
Instead of
petition.
14, let it be on 18th.
18th, very well. 18 July.
Get movement.
Next.
Item 2,
You have filed the application, review application. Now last, your last, you see the last order,
Review application.
30th March. By initial order, your lawsuit died to the authority concerned to consider our representation. But it was the authority concerned, yes, we are review. We also got the liberty to file the review application of the original order. We filed the review application, but I give you the number. The review application that has not been listed.
Take the microphone.
Yes.
Appropriate. They should be come in the original application, my lord.
I
For that
think
is
he
my
has filed a
lordship.
review application.
Yes,
Well,
but
that-
your lawsuit is ordered 30th
Your
March.
lordship can allow that application, my lord.
Have you received a copy of the review application?
But I had a word.
Please serve a copy.
Yeah. But your lawsuit died to give liberty so that district
The
magistrate,
review application.
the chairman is the authority.
It is not in the file also. Let
Then,
it
my lord,
appear.
tomorrow, your lordship can,
Let it appear.
my lord,
Yes, you
I
can.
have no any objection, my lord, to
Come back next
allow
week,
that.
because I have to
Yes,
bring
ma'am.
it
And let the
back.
review
ma'am.
be listed. Yes, yes. I'm giving the number.
I have no any objection, my lord. Otherwise, my lord, he will not get the money. Only for that reason.
Yes, only.
The review application
Number 2,
filed on behalf of the applicants is not in the file. Paragraph, the department is directed to put up the application along with the file on the adjourned date. Paragraph, let the matter appear under the same heading on 21st June,
Yes, ma'am.
next week,
Next.
21st June.
21st June. Next Wednesday.
Or next Wednesday. But they are preparing. My advocate record, he will be on 1 week, he will not be here.
Very well. So 26th June, the week thereafter,
Yes, yes.
26th June, along with the review application.
Yes, yes.
Done.
Next is the same.
Next, same matter.
Next
Same,
is
same.
also same order.
Yes,
Same.
ma'am.
item 3,
I don't let it be the way.
Same
Same
order.
matter.
review number din.
Today review number 3.
Number 3,
Number 3, একটা 18 একটা 19.
Next,
item 4,
I put the contempt.
applicant,
The last
Or-
question, my lord.
The item 4, my lord, I appear for the petitioner, my lord. My lord had directed, my lord, to disburse the payment, my lord, compensation along with an interest as the amount was lying with the authority from 2014, my lord. My lord, they have disbursed some amount, my lord. However, my lord, no notice under or intimation under 12(2) has been given.
But in
And
this
no
connection, my
interest
lord,
also.
we have filed one application for recalling of your lordship's order, my lord. That application with the record, my lord. Let the application be hard fast, my lord.
Can an order passed on merit be recalled? Where is the provision?
But we have just applied for review or recalling, my lord. Some points that there, my lord, that has to be, my lord.
On merits, it cannot be dealt with, sir. I'm
Not on
sorry.
merit, my lord. First part of the order has already been complied with, my lord. Payment has been made.
The interest part you are.
Interest part, my lord. That cannot, not able to pay, my lord, because of the fact that the amount is deposited the amount with the PL account of the collector. And the PL account, my lord, does not credit any more interest. That is the, my lord, problem. That is why the
Government
interest
will
part.
pay from its own pocket?
That is, my lord.
And my lord, 2 of the petitioners were not paid, my lord.
The order does not say interest accrued from the PL account.
You must only hold
Since
that.
the amount was lying since 2014,
Yes,
interest has to be paid.
lordship, please to hold that they are entitled.
Petitioner suffered.
Your lordship, please to hold that they are entitled to my interest, my lord.
Yes.
And that,
You decide on the interest and pay. I have not stated the amount of interest to be paid. The rate of interest has not been assessed by the court.
no, my lord, but the
So
no
decide the
interest.
amount to pay.
Only, my lord, our point is that no interest is accurate. That is lying with the PL account and PL does not get any interest. That
So
is why
that cannot be a ground for non-payment of interest. Why will the petitioner suffer?
it's a public money. That is why.
There is the review application.
Yes, my lord, can one, my lord.
This
that
is
is
a
with the
can
record.
application, my lord.
Can one.
Yes.
Application for recalling and or modification of the order dated 17/3/2022, my lord. But,
Cannot be done on merits.
Only, my lord, interest
Go-
part. That
Go before the
that part,
division bench.
but paying my consideration of your lordship, kind
Cannot be
consideration.
done on merits. I'm sorry. Yes, are you ready to make your submission on the review application?
But so far as the review application, the only one point has been taken, that is at page, my lord, 13, para 10, my lord. That is PL account does not accrue any interest, so they are not able to pay interest, my lord. But fact remains, my lord, 2014, my lord, since 2014, funds were lying with them, my lord. They have not disbursed, neither they have not taken any steps, my lord. Till today, my lord, 12/2 notice has not been served. We are not able to understand, my lord, the details of the.
No, my lord, no. We have, my lord,
Disbursement.
we have annexed all the documents with our my lord, application. That
No, that is some
we have, my lord,
bank
even-
account and some what amount of money has been disbursed. But the details,
the detail we have
Okay.
also, my lord. Can you see page 40, my lord? Pursuant to their application, we have supplied the details, my lord.
and unless 12/2 notice is given, my lord, no reference can be done, nothing, we can proceed, my lord. That is, my lord, new technique has been adopted.
Can we see, my
Money
lord?
is sent to the bank, no details are given, so the entire process, my lord, is stuck up.
When was the money sent to the bank?
My lord, page, my lord, page, my lord, 26, my lord,
Of
of
the-
my application.
Of the application?
Yes, my lord.
Around April 2023.
22. This was sent in 2022. The transaction date, and even in the first box, it is
Yes.
21st October 2022. So 2014 to 2022, it was lying with you.
Just lying with us.
You
my
have
lord.
not even issued a payment notice under 12(2). So who is responsible?
My lord, the payment could not be disbursed due to, my lord, they have not substantiated their title, my lord. That is why they have moved before your lordship.
Please show me the document that you have issued a payment notice and they were unable to substantiate their title.
That is not with me. And
Please show me some document.
that documents I do not annex, but I have not annexed in this application, my lord.
So there is no reason for modification. Please pay the amount. This application will be rejected. And it cannot be modified on merits.
We only this part, my lord, interest
Not
part,
at all,
first
not
part
at
we have
all.
complied with, my lord.
Not at all. You have to pay interest. 14 to 22, the amount was lying with you.
This is lying with us.
Until date, you have not issued a payment notice.
Payment has been made, my lord. The notice,
The principal amount has been made, but you have just put it into the bank of the petitioner.
no, thereafter we have, pursuant to their request, we have supplied the, my lord, breakup, can you see pay
That is all after the writ petition,
after it?
not prior to that.
Okay.
Only after the order of the court was passed,
Yes,
not before that.
no.
So since 2014, how do you justify keeping the amount with you without issuing a payment notice?
But payment notice issued or not, that
The
I,
amount would have accrued interest if it was lying with the petitioner in his account.
the notice, whether notice has been issued or not, that instruction I do not have right now, my lord. If your lordship direction, I can, my lord, put on record by way of filing evidence.
This court will not direct anything. You have to substantiate your case, which you have not been able to do. And no review can be allowed on merit. You have not paid for a review, you have paid for a recall.
Well, let them produce the
Recall.
award copy,
Calling
my lord, everything
modification
will be clear.
is not allowed, not permitted under the law. You should have approached the division bench if you were aggrieved.
That we do.
So let me dispose of this application today, here and now. Yes, Mr. Buttercup?
No, our only submission is the only interest part. The reason we have, my lord, stated in paragraph 10. my lord.
Anything to add?
Let them produce the award, my
Can
lord.
1 of
Everything will be
2023.
clear. ma'am.
Then, my lord, probably some time, more time may be given, my lord, so that we can, my lord, interest part we can consider, my lord.
So let this be kept pending in that case,
Let it be kept pending, my lord.
or will you not press the review application? The can?
But can you fix another day? I shall take instruction, my lord, so far as the interest part is concerned, my lord. The next day,
This
we
is
will
an
not.
alternative, you have to pay, sir.
Yes.
And let
Let
them
it
come
get-
back.
Yes.
On prayer of the, can 1 of 2023 the order. करूं. On prayer of the applicant, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17th July. Sufficient time, please come back with instructions.
Yes.
My lord, kindly, my lord, direct them to take instruction, my lord. My instruction is that 14 and 15, my petitioner number 14 and 15, they have not been paid, my lord. Relating to that, my lord, they let them take
Out
instruction.
of, there are 25 writ petitioner, my lord. All the writ petitioner was sub notice, my lord. Out of, my lord, 25 writ, 22 has been, my lord, proved their, my lord, title, my lord. They have been paid, my lord. 22 writ petitioners have been paid, and rest, my lord, could not, my lord, substantiate their title. They could not produce any documents. That is, we have stated in our application, my lord.
Come back.
We'll take it.
Mr. Buttercup says he has stated that in his application. So please find out. Yes, next.
Item 5,
I know Mr. Oyan Banerjee is appearing in this matter for the petitioner, your lordship. I'm praying for an adjournment, your lordship.
I appear for the arrangement.
On prayer of the applicant petitioner, the matter is adjourned. Let the matter appear under the same heading on 13th July.
Deeply, your lordship.
13th, 1-3.
item 6,
Unlucky 13.
Not always.
For me, my lord.
Yes.
I am for the petition.
Is it appearing for the first time?
No, 6. I suppose. So there are two matters, Pinky Roy and Arindam Roy. Arindam Roy was taken up, my lord, last week. I submitted an affidavit of compliance. My learned friend wanted to take instructions in the matter.
Pinky Roy.
This is Pinky Roy. The lordship kindly recalls,
Have
my
you
lord, this
complied
is,
with the order?
I've already complied with this is with regard to the ponds. Under
Your
the
affidavit
urban,
of sub-
under the Urban Land Ceiling Act, we cannot waste the pond.
Your affidavit of compliance?
Your lordship, some mistake in the said final statement, your lordship,
Some mistake in the
occur in the final statement, your lordship. Your lordship,
final statement?
yes, your lordship, one pond, your lordship, included as plot, another is your lordship, as premises. So therefore, it should be your lordship rectified the check, the final statement.
Beseech my learned friend to serve me a copy of the contempt application. I'll come up with the affidavit of compliance.
You have not served a copy?
Your lordship, earlier question has been,
I'm missing it, my lord.
I served the department, your lordship.
আমাকে একটা copy দিয়ে দিও।
ঠিক আছে, আমি দিলাম।
I'll come up with the affidavit of compliance, my lord. It has been complied. Strictly complied because I have seen this matter. There were two matters, my lord. I've strictly complied in letter and spirit.
So please file your affidavit of compliance
I'll
on the
file
agenda.
affidavit of compliance. I'll request my lord to write a copy the
Please serve an advance copy, Mr. Siddiqui, so that we can deal with the
My
matter.
lord, I'll submit it.
It is submitted on behalf of the alleged contemner that the order under contempt has been complied with. Stop. Learned counsel seeks to file an affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading. When is the other matter appearing?
ওটা কবে রেখে 10 তারিখ নাকি? ওটা কবে? পিঙ্কি রয়টা? অরিন্দমটা। অরিন্দম রয়টা?
13th July, same date.
কবে দিব? 13 তারিখ, 13 জুলাই, 13 জুলাই। তো একটা কপি দিয়ে দিলাম। আমি দেখতাম কিছু যে ওকে দিয়ে দেবো।
Item 7.
My lord, in this matter, my lord, I place some time.
Appear on behalf of the petitioner.
Because my lord, in compliance report, that is not properly.
Sign me.
So you want to come back with the compliance?
Yes, my
report?
lord.
Let him come back.
Now, my lord, only thing is this. My lord's order is very specific. If your lordship kindly have a look, my lord's order at page 21, the third paragraph. My lord, yesterday, my lord, a compliance report has been filed that has not been taken into consideration by your lordship. Kindly see, because of the reason, page 21, third paragraph, upon consideration of the submission made on behalf of the parties and materials on record, the writ petition is disposed of, directing the sixth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within a period of 3 months from the date of communication of this order, after affording reasonable opportunity of hearing to all the interested parties. There was no, my lord, hearing was taken up. At least I have not received any notice.
Because for that reason, my lord, I have seen this, that as no hearing was there, my lord, only for that reason, my lord, I pray some time.
Let him come back.
I
Yes,
have
yes.
seen.
My lord, only this
I have
20
seen.
only, okay, আমার ওইখানটাই আটকে যায়।
আরে
On
না,
prayer of
তোমাকে
the
ডাকবো
alleged
বলেই তো
contemner, the
এটা
matter is
ভুল হয়েছে
adjourned.
আমার।
Let the matter appear under the same heading on 14th July,
এই চন্ডিদা কি বলছেন? এই
14th
দর্শক
July,
Yes, my lord. 14 July.
so that he can comply in the
Yes,
meantime.
yes,
Yes, my lord.
yes. Deeply obliged, my lord. I know Mr. Dey is other side, he appraised this score properly.
Yes, my lord.
Item
He
8.
understood what is the defect in the compliance.
Item 8.
I appear for the alleged contempt. Lord, I submitted my affidavit of compliance on the last occasion. Ms. Shanti Das was,
Who is appearing for the,
Ms. Shanti Das was appearing for the petitioner, my lord.
he's not,
I inform her, my lord, your lordship kindly takes her,
some
any
other
day,
day.
some other
Yes.
day.
None appears for the applicant petitioner.
Oh.
Paragraph, let the matter appear under the same heading on 7th July.
7 July. I'm grateful. my lord.
Item 9.
Lord, I am for the alleged, Lord, I have
But
already.
9, I am appearing for the petitioner. But
Yes.
I have undergone a surgery. I am not able to come to the court. Lordship kindly grants me another 3 weeks time left so that I can come back and make
Another
my
3
submission
weeks.
before.
Very good. On prayer of the applicant petitioner, the matter is adjourned. Let the matter appear under the same heading on 11th July.
My lord, my lord.
Lord, your lordship has fixed a matter on 18 July. Both the matters can be
18.
18. If your lordship do not have.
But that is a separate matter. This is a content. Let this appear on 11th. My lord, come back on 11th.
ঠিক আছে, ঠিক আছে।
Deeply obliged.
I have already, he has to file the exception to this.
Yes,
he has
that is
not yet
ready. I
filed.
get that upon. But last 2 weeks I could not come to the court.
ঠিক আছে, ঠিক আছে, all right, all right.
Deeply obliged.
City recovery.
Right, Lord. I too,
Deeply
Lord, I too pray to God for the same.
Thank you, thank you. Obliged.
10. Item 10.
I am on behalf of the petition content application.
Yes. Have you served?
Yes.
7 July. 7th July.
Who is appearing?
No, my lord, I served.
Where is the service?
Not I only serve the container, madam.
Yes, where is the service?
Office of the land of, special land officer, my lord, that's it, my lord. Also the receive the same, my lord, I take the report, my lord.
Mr. Dev was appearing in the writ petition.
Yes, my lord.
This is a contempt application. Service has been made, but the contemptor is not represented.
My lord, give me a copy.
So
my
will
lord.
you find out?
Yes, ma'am.
Let there be a date, let Mr. Dev find
Yes,
out.
my lord.
Like only street. Only street.
Darjeeling.
Street is.
Darjeeling.
Apni-
Please give him a copy unofficially
Yes,
so
ma'am.
that he can find out.
Savra.
Because you were appearing in the.
Item number 10.
Yes, you are appearing.
Yes, my lord.
I was almost issuing rule.
My lord, I have already filed the report in the form of evidence.
Put in the form, where is the report of compliance, affidavit of compliance?
My lord,
Where is your affidavit of compliance? It is a contempt application.
real.
Yes,
Yes.
not in this matter.
Yeah,
So they please
Yes,
take
madam.
instructions.
Yes.
আমাকে দিয়ে দিও দেখো।
Affidavit of service. None appears for the alleged contemner despite service. Paragraph, let the matter appear under the same heading on 14th July.
Yes.
একটা কপি দিয়ে দেওয়া আছে।
Please give him a copy.
Yes, okay.
11,
Well, I'm appealing for the petitioner. My lord, kindly remember that matter where road challan was not issued from November 2022.
Yes, who is appearing? Have you
No,
served?
my lord, I have not served. This is the first time, my lord.
This is appearing for the first
It
time.
is first time, my lord.
Serve and come back.
Yes, madam. Kindly keep short date, my lord.
The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 10th July.
My lord, if it is possible, June, my lord,
June not possible.
because my lord, from November, my lord, your lordship specifically directed at the earliest to issue
This
that.
is for the first time today.
My
So
lord,
come back
then
to 10th July.
July first week, my lord, if you.
No, no.
My lord,
item 12,
my lord.
My lord, in item number 12, Mr. Kolal Basu is appearing in this matter, my lord, for the HIT respondent. My lord, he is on legs on courtroom number 1. My lord, I am praying for a not this week, my lord.
On the earlier occasion also you sought adjournment.
My lord,
Please be on the next occasion.
My lord,
No further adjournment will be granted.
my lord.
Who is appearing for the petitioner? You are
I am for the state.
on prayer of the Howrah Improvement Trust. The matter is adjourned. Let the matter appear under the same heading on 12th July.
My lord.
12.
Let it be 20 Monday.
Dates cannot be bargained, madam. 12th July.
13,
Worship.
Well, I for the petition in this matter, my lord. If your lordship kindly remember, this is that matter where my land of the petitioners has been taken over by the Eastern Coalfield Limited. Now, my lord, your lordships on the earlier occasions had this entire matter, my lord, and your lordships directed them because they have, my lord, initially prayed for filing of the report. They have, my lord, subsequently refused. Even my lord, last order, my lord, your lordships directed, my lord, I have not received any copy of the report, whether it has been affirmed or not. So, my lord, kindly proceed with the matter, my lord.
Lordship, I will submit. Lordship, one document I said before your lordship that there was a mining plan prior to their mining plan and operational report. That is not with my department. I have to find it from the DG Minings, Director General Mines. That is the Government of India. We have communicated. We are likely to receive by this weekend or next week, Lordship. If your Lordship kindly fix it after the third week, Lordship, we will be able to produce that. Because
This is a
Lordship
matter
wanted
of
to see
2018, and my lord, if your lordships kindly see, my lord, your lordships, my lord, 1 year back, they refused to
I-
file any report.
Mr. Ghosh is
refused.
correct in this.
Twice, my lord, they have, my lord, prayed for extension. Thereafter, my lord, it has been refused again.
Come back to the report.
My lord, subject to payment of cost, my lord, subject to payment of, because I am suffering, my lord, kindly consider this aspect.
Come back, I'll deal with it.
No, Lordship, kindly put a small cost on my client to be deposited in legal aid, that
Very
will
well.
make them awake from their sleep also.
Very well, my lord.
My learned friend is correct.
I have to record your submission, sir, in that case.
No, not in that.
Not the
case.
court's view.
No, then
So kindly, small amount, my lord, any amount, my lord.
Let them come back. We'll read.
Lordship, lordship.
Then as a last chance, kindly record, my lord.
On the earlier occasion, on the last date, he has asked for a.
Before that, kindly see a lordship's order, my lord. Kindly see a lordship's, my lord, all orders, my lord, your lordship will find, my lord, 1 year back. They refused, my lord.
Lordship, my learned friend is correct on that score. But Lordship, kindly give me last chance. I assure your court that Lordship, I will try to make it.
Learned counsel for the ECL seeks extension of time to submit the report in the form of affidavit as intended. Paragraph, as a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 10th July.
Lordship,
Please serve an advance copy.
I will.
14,
My lord, this one I am there on the petition. My lord, here in this case, my lord, direct to the DM.
Mr.
To
Dey,
cause
you are
an
appearing?
inquiry. My lord, nothing has been done by the
Mr.
DM.
Dey, you are appearing? Sir.
Nothing has been done by the DM as yet. Means I have already communicated my lord's order as well as my 2019 order.
10th July 2019 order.
Yes, my lord. Then the second paragraph, since second page of the order, since multiplied with portion of the margin of the individual utilization of land for construction of road and having regard to the position that the land has not been acquired in accordance with the law, this court direct the district magistrate to cause an inquiry by giving the petitioners the opportunity of hearing as a local officer concerned to the land in issue. Steps to pay the compensation shall then be advised in the light of the successful inquiry. My lord directed to comply with that order 2 times.
Have you
Nothing
filed a
has-
contempt application?
Yes,
Have you filed a contempt application?
no, my lord.
That is the language that the government follows, understands.
Well, I follow because my lord directed my lord to file a report after inquiry. Nothing has been done by the DM.
It was not complied with, so what was the next
That-
step that was to be, that
Yes,
should have been taken by you?
That I follow.
Please do that.
That I follow.
এই তুমি কি 151 করছো?
14 নম্বর, হ্যাঁ, হ্যাঁ।
151
Since 2019, this has not been complied with.
My lord,
And you should be thankful to
lord,
the petitioner that
I
the contempt
received,
application
my
has
lord,
not been
previously,
filed.
my lord, John Moy Bhattacharya was there, my lord. After that, my lord, I was appointed, my lord, the last week, my lord, I was appointed. My lord. And my lord, I took my lord 1 week, to my lord. My lord, your lordship can give me some time, my lord. Otherwise, he can file an application for contempt. My lord, that is the petition, according to the petition, my lord. That is the consideration of the petition. তোমার কি অর্ডার আছে এর মধ্যে?
2019
My lord অর্ডার দিয়েছিল?
হ্যাঁ, সেটা কমপ্লাই করতে বলেছিল।
জাস্টিস তালুকদার?
হ্যাঁ, সেটা অর্ডারটা কমপ্লাই করতে। Or if your lordship desire to give him another chance, further chance, well, I have no problem. If
As a last chance.
as a last chance.
My lord, I appointed.
Well, I never desire
Last
to
week,
file a
my
contempt.
March, Mr. Dey, after that, we are in June.
My lord,
Your appointment is in March.
previously, my lord, that is the, I don't know what the judge is now.
I find your appearance on 23rd March 2023. Yes,
আমার কাছে এসছে।
this is June,
এই যে দাদা, এই
23rd March 2023.
Oh.
But it is not that I have not communicated. I also communicated my lord's order.
Yes, my lord, give
As
me
well
some
as
time,
earlier
my
order.
lord.
And Mr. Banerjee has been appearing all throughout.
Yes, my lord. He was there with, along with the Justice Bhattacharya.
The order has been complied with, you say?
I'm told that the hearing was given, but it also pointed out that during the inquiry, hearing has to be given.
Yes.
Given hearing, but during inquiry process, that was clearly communicated to them. But it came, document showing that during inquiry is not given. I can't see it.
But by the whimsical act, they are my lord, less than very less, my lord, lesser, my lord.
আরে বাবা করে দেবো, তোমার তো চিন্তা নেই।
Hearing has been given, but not during the inquiry.
I'll give you a last opportunity.
My lord, I'm grateful to your lordship.
Learned Counsel for the state respondents seeks further accommodation to comply with the order passed on 10th July 2019. Paragraph, as a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on
Only short date, man, because of that date, your lordship, my lord,
4th July.
4th July. July,
If it is not complied with, necessary steps will be taken.
মানে এটা কি এই কমপ্লাই কে করবে? ডিএম
Yes.
15,
আই এম গ্রেটফুল ডক্টর।
Next.
15,
I appear on behalf of the petitioner. In this matter,
Respondents?
the lordship, direct.
I pray my lord that the so-called should be
Report.
my lord, your lordship will see the order on the previous occasion. My lord, up till now, my lord, they have not returned. So my lord, I have nothing to say, my lord. Your lordship can issue rule against him. Yes, my lord. I know, my lord. I personally, my lord, submit before your lordship that it is not possible for me, my lord, to. My lord, my two copy was also handed over to them, my lord. In spite of that, without, so my lord, your lordship can issue contempt against.
Let rule be issued.
Yes, my lord.
Let rule of contempt be issued against this person. The special land acquisition collector. No report in the form of affidavit as called for has been submitted by the state respondents as yet. By an order passed on 8th May 2023, this court directed submission of the report, failing which the Special Land Acquisition Collector, Department of Special Land Acquisition, Government of West Bengal, being the sixth respondent herein, was directed to personally appear before this court with the report in the form of affidavit and submit an explanation as to why the order of the court has not been complied with. Stop the said next. Have you served the private respondents? You are appearing for the private. You are appearing for? The state is also a party, isn't it? Yes. Who is appearing for the state?
I've served the notice, my lord.
Service from the state?
Yes, my lord.
Earlier option Vivek Vasu was appearing, after that one Mr. Ghosh is appearing.
Just received upon the letter.
May I request Mr. Dey to appear? State has been served. Please serve a copy of the writ petition to Mr. Dey. After the writ petition, copy of the writ petition.
Present,
Requesting him to appear in this matter. For this.
present.
Yes, what is the matter about?
The petitioner occupied the land more than 43 years. With the consent of the then landlord, one Bhudai Mandal. And the land was now acquired by the National Highway 34. And his name is also appearing in the serial number, my lord, P1, my lord, 117. Page 24, a fresh copy.
Yes. Yes, then.
But the land, special land officer disbursed the amount to the private restaurant, but they are not the owner of this land anyway. They are the owner of the second plot, but they are acquired the first plot. But petitioner filed the representation, but they also not considered. On page 35 to us onwards. The petitioners of occupier, they PD also filed, issue a certificate, the Gram Panchayat, local MLA, and they are constructing a building under the Indira Abasan Yojana scheme. But surprisingly, the compensation money was paid to the private respondent.
You have several representations. Which
Yes, my lord.
Which one do you want to be considered? Which one?
Page 35. Madam, 36, my lord.
Yes.
36, 37, both are 36, 37, both are P4.
36 was recommended by the member, not necessary.
Hmm? 37.
Yes.
Respondent number 5, my lord.
There is some defect. Here and now. So please implement the special land acquisition officer as a party. Here and now.
Here and now at the party, my lord. And I have served the copies, my lord.
Draw anything to add?
Well, only the date, my lord. In the year 2016, my lord, they filed these representations, my lord. Only the, my lord, whether there is any delay, lordship, has been explained is this. Only this portion, lordship, I have, otherwise, lordship, my learned friend is the answer.
Recommended.
Only the representations, lordship, I have only.
16 to 23, the government has not taken any steps. So the petitioner only cannot be.
No, lordship, that,
Isn't it?
As
My
per
lord,
petition, I have
my lord, one more prayer, my lord. In the meantime, not to disburse any amount for any further compensation.
Yes, no amount will be disbursed because there is a dispute. It should
one
actually be
more
referred.
indulgence, my lord, I have served him a copy.
Affidavit of service. And none appears for the respondent, for the state respondents and the private respondents despite service. Mr. Dev, regularized current service, copy service in direction. The petitioner claims to be the recorded owner of the plot in question and submits that though the said plot has been acquired by the state respondents, comma, compensation for the same has been paid to the private respondents who have no right, comma, title or interest in respect of the said plot. Stop. The petitioner has been deprived of his legitimate claim of compensation in lieu of the acquisition. Stop. The petitioner submitted representation in this regard before the concerned authority on 8th September 2015. Page 37 is a subsequent representation. 37, 38, there is 38 is
36, 37, my lord.
36 and 37 be considered. Submitted representations before the concerned authority ventilating his grievance on 8th September 2015 and 16th October 2016 respectively, which are yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the 12th respondent be directed to consider the representation at the earliest. Paragraph, in view of the 12th koro add korte hobe. In accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the 12th respondent to consider and dispose of the representations submitted by the Agata representations. Last line. Na tarpore in accordance with law representations. Status sufficient. Consider and dispose of the representations submitted by the petitioner dated such and such duto date given. Within 2 months. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, pending disposal of the representation, comma, no further amount of compensation in respect of the plot in question shall be disbursed to any person by the concerned authority. Disposed of on prayer of the petitioner, liberty is granted to implead the special land acquisition officer, comma, 24 Parganas North, comma, Barashat, as respondent number 12 in the petition. Paragraph, the cost title of the petition be amended accordingly. 12, 11 is there. 12.
I have no.
Much obliged.
Yes, next.
Petition.
17.
Lordship, I am for the petition, Lordship.
Yes.
It was substantially hurt by your lordship.
Yes.
My lord, besides my lord was my lord submitting before your lordship.
Oh, this I've heard that.
I talked with my lord, and my lord.
And he was making very powerful submissions, I remember. On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 13 July. Sufficient.
Last chance chilo aage.
13th July, one.
15.
On behalf of petitioner, I am praying not today, my lord.
Yes,
On behalf of petitioner, I am praying not today, my lord.
yes.
I am praying not today.
My lord, on last occasion, your lordships will not pass an order, it's the last chance, your lordships kindly
We
consider.
have taken advantage of several advantages.
Will not be allowed. Make your submission.
My lord,
Please make your submission, otherwise it will be dismissed.
learned advocate, his son is, that's why he doesn't come.
Please do not make such submission, not today. Let you come back tomorrow.
And
Not today, not today.
18 and 19.
Not today.
18 and 19.
19.
তাহলে time কবে?
20.
না, not today বললো, কালকে।
20.
I will answer the petitioner in this matter. My pursuant to your lordship's last direction, last direction, I have served upon all the respondents and this is my affidavit of service.
Mr. Dhor is appeared for the state. Where is he?
My lord, the subject matter of the dispute in this matter that the state government has taken certain policy. We have filed this writ petition against the state government policy, land policy for issuing the freehold title as title deeds, lease deed or sale deed to the occupier in respect of the land. But the state government has taken an arbitrary
The
decision.
railway is the petitioner in this.
Yes, yes. Because our land, railways land, have been wrongly taken over by the state government and thereafter they issued the freehold title deed and the lease deed to the refugees. If your lordship kindly take page 30. My reading.
Mr. Supratim Dhor was appearing on the earlier date for the state. Today I do not find him.
Shall I intimate him?
Yes, I'll give you another date. Please intimate him. Only the date.
Hey, Madam, kindly give me after 22nd
After 22nd of
of this month.
this month. Yeah, it will be in July.
Or kindly date may be kindly be fixed.
Yes, yes, absolutely.
Because they are now issuing the pattas.
None appears for the respondents. Paragraph, let the matter appear under the same heading on 6th July. 6th July. Paragraph, the petitioners are directed to serve notice upon the respondents intimating the adjourned date.
All
You
the
can
respondents
inform
of,
Mr. Dhor also. He is appearing.
and Madam, the affidavit service is kept together.
It's taken. Deputy Service Police.
Supratim Dhar.
Next.
21. 21.
Petitioner. Termination. Who is appearing for the petitioner? No one? In view of
Lordship,
yes.
earlier occasion due to detail.
Petitioner is not there. In view of change in determination, comma, this court has the determination to deal with the present matter. Paragraph, none appears for the petitioner. No accommodation is sought. Dismiss for default. Next.
22.
Mr. Roy is in his leg from courtroom number 652, my lord.
Kindly recall. Argument was completed.
Only thing I will place judgment regarding whether if the public law element or then replies, otherwise not. Here the my lord, the main file is purported requisition number 2. My lord,
is asking
in
for time, so please come back. You're not in this one. You're not ready to make
No,
any
Lordship.
submissions.
my lord, late he is coming. I had a talk. He is coming.
This is all you're appearing in this one?
Yes, my lord, I am led by Mr. Rai. My lord, only my lord, the main contention which they have urged in filing this purported writ petition to implement the terms and conditions incorporated in the agreement. Settlement deed. I say that settlement deed is not a statutory contract and no statutory duty cast upon the authority to implement the same. Main approach, if he agreed, if there is a violation of the terms and conditions in the that deed, then you have to approach the civil court because no public law element is being involved.
Property.
Yes, puri property. Now, my lord, I am first relying upon my lord 2010-11 SCC. My lord, I only show my lord only and like I need recall, just asked me, Mr. Sengupta, you just rely to judgments where there is no public law element, no reply. That judgment I have, my lord, I am placing. My lord, first 2010-11 SCC, paragraph 80. My lord, I am relying.
Have you given the citation?
Yes, I have. 2010, well, this is SCC on
citation
2010-11 SCC. আমি তো বললাম 2010-11 SCC 186. ওই তো, yes.
The relevant paragraph?
Paragraph 18.
1818.
18, my lord. Kindly say I am reading. My lord, got it? Paragraph 18.
পেজটা
Page এখান থেকে এটা তো ইয়ে
10-11 এসসিসি পেজটা তো বলবেন
ও 186 বললাম তো 186. My lord, next decision relied on by the learned senior counsel of the appellant is Kerala ACB versus Kurian versus Kalia. He heavily placed on reliance on paragraph 10 and 11 of this judgment, which is that. Kindly see. We find there is a merit in the first contention of Mr. Raval. Learned counsel has rightly questioned the maintainability of the writ petition. The interpretation and implementation of a clause in a contract cannot be the subject matter of a writ petition. Whether the contract envisages actual payment or not is a question of construction of a contract. If a term of a contract is violated, ordinarily the remedy is not the writ petition under Article 22-26. We are also unable to agree with the observation of the High Court that the contractor was seeking enforcement of a statutory contract. This is not a statutory contract. A contract would not become statutory simply because it is for the construction of public utility and it has been awarded by a statutory body. We are also unable to agree with the observation of the High Court that since the obligation imposed by the contract or the contracting parties come within the purview of the Contract Act, that would not make the contract statutory. Clearly, the High Court fell into error in coming into the conclusion that the contract in question was statutory in nature. Pausing here for a moment, the deed which they are relied upon for enforcement cannot be treated as a statutory contract. And my lord, a statute may expressly or impliedly confer power on a statutory body to enter into contracts in order to enable to discharge this function. Disputes arising out of the terms of such contract alleged breaches have to be settled by the ordinary principles of law of contract. The fact that one of the parties to the agreement is a statutory or public body will not by itself affect the principles to be applied. The disputes about meaning of covenant in a contract or its enforceability have to be determined according to the usual principles of Contract Act. Every act of statutory body need not necessarily involve an exercise of a statutory power. Statutory bodies like private parties have power to contract deal with the property. Such activities may not raise any issue of public law. That I am, my lord, I have raised that. I have made submission that.
In the present case, it has not been shown how the contract is statuted. The contract between the parties is in the realm of private law. It is not a statutory contract. The disputes relating to interpretation of the terms and conditions of such a contract could not have been agitated in a petition under Article 220 of the Constitution. That is a matter for adjudication by a civil court or in arbitration provided in the contract. Whether any amount is due, and if so, how much refusal applicant to pay or is justified or not, are not the matters which could have been agitated, decided in a writ petition. The contractor should have relegated to the other remedy. Now, my lord, kindly pausing here for when the principles of law laid down, if there is no public law element is being involved, and if there is no statutory obligations, and if the contract is not in the statutory nature, then it will become within the realm of private law. And enforceability, if you want to implement the terms, you have to approach the civil court. This is the, my lord, whether he will agitate and he will make submission that this is the facts that differ in money, claiming money, but principles that has been laid down in this judgment, Honorable Apex Court, that is very clear. It is not for this, my lord, it comes from 1969. The principles. If even in one of the judgment I could not find that the difference between the public law element and private law is still subsisting. It has not been erased by the judicial process. Yes, my lord. Another judgment I am relying, my lord. My lord, this is 2006 10 SCC, page 1.
The relevant paragraph.
2006 10 SCC, page 1. My lord, paragraph 92 and 101. And my lord, so many regarding extent of judicial review. This my lord is actually, my lord, doing the judicial review, whether my lord will entertain this writ petition or not. This is within the jurisdiction under the heading judicial review.
Please give the judgment.
I have already said 2006 10 SCC, my lord. Binding na kore to binding at a year. My lord, 92, my lord, I am, my lord, after binding, my lord, kindly go through, and my lord, 92.
Please mention the paragraphs on the top.
92, I have, my lord, marked and stapled as
In the first.
staple করে তো পাওয়া যায় না দর্শক।
ক্লার্ককে বলতে হবে বাইন্ডিং করে দিতে, আমরা স্টেপল করে দিতে পারি।
হ্যাঁ,
তো এতটা একসঙ্গে স্টেপল হবে না।
হয়ে গেছে? বলা কমপ্লিট?
হ্যাঁ, আমি তো
বলা কমপ্লিট তো?
এত বড় স্টেপল
এইটা কিছুটা করুন, তারপর আমি মানে প্যারাগ্রাফ দিয়ে
Mr. Roy, will you come back because the judgment is not ready, I find.
well, judgment is ready, my lord. Yeah, only I will hand over, my lord. I am only placing that, my lord. I have got nothing to submit. I have completed.
Will you come back?
No, I'll argue on the basis of the.
Yes, 92 and well, এটা করুন। তারপর আমি বাইন্ডিং করে কেস সব এই ইয়ার বল সুসুটা নিয়ে আসতে কবিকে কাম নামে যাস না, হ্যাঁ সেলাই করে নিয়ে বাইরে চলে গেলাম আমি জানছি।
So Shenmukh, why don't you come back on the next day?
Well, this is not fair. Well, I am right now. I have instructed my junior so that he can bring that stitch and.
I go through the judgment.
And Malad 92, Malad, kindly see.
Monday, I'll just make it.
Malad, I want to finish it off. Malad, kindly.
Not today. You should have been ready.
Malad 92, Malad, I am placing. Malad, I have. So for my part is
go through the.
92, yes, my lord, I am handing over. এটা বাইরে নিয়ে আয়, বাইরে সাইড সেলাই বক্সটা নিয়ে চলে।
Mr. Roy, not today. Come back on Monday.
92, my lord.
Monday.
My lord, 92,
Get it ready, come back on Monday.
my lord, 92, my lord, right now, my lord, kind. My lord,
This is a court of law.
no court
You
of.
cannot be so.
No, no,
careful
no,
with the
no, no,
court.
I cannot. My lord, at 2 p.m.
Not today.
Not
Monday,
Not
Monday,
today.
Monday. Well, if your lordship wants, because
Oh, you come back tomorrow? Tomorrow
I'll
is
come back
Saturday.
tomorrow and because this is a point which is raised regarding maturity. So, but the other point he's not raising or I do not know.
At the moment.
আর
At
কি
that
আছে?
moment.
আর কি আছে? যশ সাহেব তো এটাই কোয়ারি করেছে আমাকে।
So,
I have to go by whatever. My lord, it is ready, my lord.
I have to wait for your speaking, Mr. Singh Gupta.
Joseph বলেছেন কালকে
23. Item 23.
Petitioner, you are appearing?
Yes, my lord, learned advocate appearing on behalf, my lord, in this matter, my lord, kindly not today.
There is a service
It-
affidavit. You do not know anything. Great. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 17th July. 1-7.
Grateful, my lord.
24.
24, my lord, I beg to appear on behalf of the petitioner. my lord. This is my current affidavit of service. My lord, on intelligence, my lord, though it has been prepared, my lord, but affidavit, but has not been affirmed. May I file is on
Service is complete.
service complete, my lord. My lord, may kindly,
So let there be a short date.
my lord,
Today I do not find anyone.
my lord, may kindly check if your lordship so desire, my lord, may check it up, my lord. Commissioner, track report.
Come back on 20th next week.
28th, my lord,
20th, 20.
20. Very well,
Let us see if the others appear.
my lord.
Since affidavit of service is not ready, let the matter stand over till 20th June, 20.
I'm grateful.
Twenty-five.
I am for the private respondent number 13.
My lord, I am for the petition in this matter. My lord, this matter with regard to my lord illegal construction over the my lord highway, WD highway. Now, my lord, the matter was taken up earlier. My lord, when my lord, my complaint at page 35 and 36 in front of my landed property.
State.
My lord, state was last occasion appeared and my lord, this is my affidavit of service. And my lord, during pendency of this
No one appeared, sir.
and during pendency of the writ petition, my lord, there is a my lord, the order passed by the my lord, the assistant engineer with regard to demarcation.
So your representation has been considered.
My lord, demarcation was my lord, directed to be conducted. In the meantime, my lord, pendency of the writ petition. My lord, the assistant engineer directed my lord, the block land and reform officer to Mathurapur to conduct an inquiry with demarcation with regard to my lord, the plot of land of the PWD which is enclosed by the private respondent. My lord, this is my lord, I won't say this. My lord, this is with regard to a similar order in respect of the same matter, other matter.
Let it be completed within a.
And my lord, what has happened? My learned friend on last occasion submitted that there is a suit. My lord, what has happened after filing of the writ petition in respect of my lord, my petitioner, my lord, they filed a suit in the civil court. My lord, in the said suit, my lord, neither the assistant engineer nor my lord in the highway authority was made a party in the said proceeding. Now, my lord, your lordship is no, my lord, section 22 of the West Bengal Highways Act. Any civil proceeding or civil suit is absolutely barred, my lord, of the West Bengal Highway Act.
Have you withdrawn the suit?
I not filed the suit. They filed a suit. They filed a suit to escape from the highway authority. After filing of the writ petition, they filed a suit to escape that they suit for declaration. In the said suit, my lord, no one of the my lord, the highway authority was the party. And my lord, with regard to my lord, the property, this is the Rayati property is the subject matter over the my lord, the civil suit. But this is the property which belongs to the PWD. My lord, the PWD authority is my lord, free to my lord proceed with the my lord the proceeding under the Highway Act. My lord, suit with regard to my lord the property which is my lord belongs to the Rayati under the Rayati Khotiyan. And now my lord, you also kindly
State in this matter.
now you also kindly
Mr. Dey, may I request you to appear in this?
my lord, you also kindly direct them to conduct or conclude the my lord the demarcation, and if it is found that the PWD land has been encroached, then my lord landlord can raise his voice. But my lord, today he is my lord obstructing the my lord, Highway Authority for proceeding with the my lord the Highway Act on the ground on the my lord the plea that there is a suit is pending. Now my lord, you also kindly see the section 22 of the West Bengal Highway Act once.
22 says civil suit is barred.
Barred.
Right. So let us hear the private
My lord.
respondents.
My lord, this writ petition will be non-maintainable, my lord. Why? My lord, kindly come to the page 39 of this lordship bill.
39.
Page 39, my lord.
Yes, page
My
39.
lord, I'm reading Ashalata Mondoler Nam Barabar. My lord, got it, my lord.
39, where are you?
39, page 39 of the annexure page, my lord.
First paragraph, page 39.
Second paragraph. First paragraph. And the just last four line, my lord. Ashalata Mondoler Nam Barabar Dan Korea Sotto Dokoli Tagi Hoen. Ashalata Mondol is the petitioner here. পরবর্তী কালে আশালতা মন্ডল পরলোক গমন করিলে, that means the petitioner has died long years ago. My lord, that is the lordship brief. Petitioner is the আশালতা মন্ডল, my lord. করিলে, my lord, got in, my lord. Petitioner is the আশালতা মন্ডল. My lord, kindly see the Bhokalarnama filed before your lordship.
What is this document that you are showing?
My lord,
This is a
this is
power
their
of attorney.
my lord,
Power of attorney.
my lord, kindly see the Bhokalarnama first. Signed by Ashalata, who has already died long years ago. But can you imagine her son? He's a government servant. He's an employee of land revenue department. He is forging her mother's signature before the Honorable High Court, my lord. In that regard, he has also filed another writ petition where the writ petition has been dismissed.
The writ petition has been signed by Alok Mondol.
He is the power of attorney holder.
My
With
lord, power,
regard to
Bhokalarnama,
Asalata and Sundarani.
my lord, Bhokalarnama signed by Ashalata. How it is possible, my lord? She has died long years ago.
Well, the Sundarani and
No.
Asalata is the two parts.
Your document says that Ashalata is no more there.
My lord.
Well, there is a power of attorney of Asalata and Sundarani. Well, Sundarani is still alive. Well,
But how did Ashalata Mondol sign on in the Bhokalarnama?
Asalata is represented by there is a power of attorney.
Do you want me to take cognizance of this?
Yes.
My lord, Asalata and my lord the Sundarani.
Forgery is a criminal offense.
No, my lord, the power of attorney is there, my lord.
The Bhokalarnama signed by Ashalata Mondol, who is a dead person. This is forged.
No, my lord, Asalata is never signed. Asalata sign was my lord represented by his Topona Alok Mondol. Asalata never signed that Bhokalarnama.
Asalata expired long years ago. Before
Asalata never signed
this power of attorney, before this power of attorney, she expired.
এটা দেখান তো ওনাকে। The Bhokalarnama has been signed on, this is, the date is এটা দেখান তো ওনাকে। This is the signature of Ashalata Mondol in the Bhokalarnama.
Well, completely forgery committed by her son, my lord. He is a government employee.
Check, sir, before you make further.
He is a government employee.
My lord, the Asalata Mondol and Sundarani Mondol signature is Alok Mondol, who is represented by the
all signature different.
The first signature, it's all different signatures.
Different signature.
My lord, in respect of power of attorney
Two
holder.
options, sir. You have to withdraw, or I have to send this for taking cognizance for a criminal offense. This is
Heavy
forgery.
cost should be imposed, man. Otherwise, he will another petition by this ground.
Asalata, my lord,
Heavy cost. Man, heavy cost should be imposed, my lord.
He has expired long back and he's signing.
Yes.
The no.
Man, being a government employee, how it is possible, my lord?
And no liberty will be granted. Learned counsel for the writ petitioners seeks to withdraw the writ petition. Paragraph, such prayer is allowed. Accordingly, the writ petition being WPS such and such is dismissed for non-prosecution. There should
My lord,
not be an order as to cost.
my lord, one pair, my lord, kindly give impose some cost, my lord. Otherwise, my lord, this petitioner will file another
I am
petition.
not allowing liberty. He cannot file a fresh petition.
Get my lord.
It is a- Please be careful, sir. Next time you may not be so lucky.
No, I should have.
Next matter.
26. Item 26.
This is I am for the petition.
What is this?
This is my editor, sir.
Yes. Who is appearing?
This is with regard to, my lord, the page 43, my lord.
Give me a minute, please. Private respondents have been served.
This is all our stuff. You also I am obtaining the tag report also.
Who is appearing for the state?
On page 43, my representation in regard to my lord illegal construction of a OPW.
Mr. Devi, I request. PWD Road.
PWD road and my lord page 43, my representation, my lord, it should be called. Post of my lord, as per the West Bengal Highway Act, my lord, by the respondent number, my lord.
Representation at page.
Representation is on page 43.
Please serve a copy to Mr. Dev.
Representation is completed by the respondent, my lord.
Affidavit of service, none appears for the respondents despite service. Mr. Dev, appointment regularized code, copy service and direction. Paragraph. The petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining his plot, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on, what is the date of your representation? An earlier representation, an earlier petition was filed by you. The same land? The same land? And the same private respondents? Dated 17th October 2022, which is yet to be considered. The petitioner prays for a direction upon the concerned authority to consider the representation at the earliest.
Earlier order on 10th of May 2016.
At page,
Page number 41.
in an earlier writ petition filed by the petitioner on the same issue, comma, being WP 7585 within bracket W of 2016, comma, a coordinate bench of this court, comma, by an order passed on 10th May 2016, comma, directed the Block Land and Land Reforms Officer to demarcate the plots upon service of notice to the petitioner, comma, the junior engineer, as well as the private respondents within a stipulated time frame. This court further directed that in the event encroachment was found upon demarcation, comma, the assistant engineer shall be at liberty to, assistant engineer would be at liberty to take necessary, to take the proceeding to its logical conclusion strictly in terms of Section 10 of the West Bengal Highways Act. The alleged encroachers were granted liberty to raise all points in their defense before the executive magistrate having jurisdiction, comma, if at all the reference was made to him in terms of Section 10(2) of the Act. Paragraph, it is submitted on behalf of the petitioner that despite such order of this court, comma, demarcation has not been done.
Not yet been done.
No step has been taken by the state respondents for demarcation of the plot in question or initiating necessary proceedings under Section 10 of the West Bengal Highways Act 1964. Paragraph, it is submitted on behalf of the state respondents that the sixth respondent be directed to consider the representation submitted by the petitioner dated such and such in accordance with law. In accordance with law. Paragraph, in view of the above, this court is inclined to hold that since in view of the in view of the শুরু করেছিলাম না সেন্টেন্সটা ওটা কেটে দিই accordingly this court is inclined to hold that in view of the order passed by the coordinate bench on such and such, comma, the representation submitted by the petitioner, the sixth respondent is directed to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in terms of the observation made by this court in the order passed on 10th May 2016. Disposed of which? It is stated in the earlier order in detail. So I've said in terms of the earlier order.
It has not yet been done.
The whole thing will be done within 3 months. The entire exercise. Not necessarily, you'll be given opportunity of hearing. You have to lead evidence. 10(3)(7).
26.
27.
I am for the petitioner, madam.
Respondents?
My lordship, today, all affidavits have been already given, reports and documents have been exchanged. Lordship, my sands have been seized by them, the authority.
Your
Sand.
sand,
I'm a lessee in respect of one
sand
sand
mining
block
block, yes.
and kindly come to the impugned order, which is I'm challenging. There was a petition before your lordship where your lordship directed them to consider and dispose it of. Kindly come to the impugned order, the impugned portion, which is in page
Learned
55.
Counsel for the respondents sought to produce the rules.
Rules. Now, Lordship, what I have done, Lordship, let me place this. Lordship, no, page 55 once. Lordship comes. They said that whereas the offline permit mandated not to stock above the quantity declaration submitted for the purpose of offline permit. The fine on stock made within the declaration submitted for offline permit, but above yearly mining plan limit was allowed by DCCB meeting held on 30th May 2022. This was considering the offline permit issued with criteria of storage quantum declaration, as the petitioner had submitted a prayer on willingness to pay the fine. Thus, the penalty on excess of storage above mining plan, but within offline permit declaration was decided by DCCB. Further, DCCB has decided to seek clarification from Department of IC, Government of West Bengal regarding the part of the stock that was exceeding even declaration limit. Now, as the sand stored is above the declaration permission limit, the same will be disposed of according to memo dated 12/8/2022 of the Secretary of Department of Industries, Commerce and Enterprise, wherein it has been stated that in case of any stock found without any permission, the same is to be seized and auctioned following the due process as per prevailing rules. Now, Lordship, I am on this. It says that once it is found that there is the excess stock above the permitted limit, then there will be seizure and seizure would be followed by auction. Now that is the done. They said that it is done on the basis of a decision dated 30th May 2022 held in a meeting. Now, and as per the memo dated 12th August 2022. Now, Lordship, kindly come to their reply. Kindly come to first the rules. I will place 3 rules which I found that relevant in this particular juncture. All rules starts from Lordship, the West Bengal, the Mines and Minerals Development Regulation Act 1957. Lordship, kindly take section 15. This power of the state government to make rules in respect of miners and minerals.
Yes. Section
Section 15.
50.
Power 15. I am on Mines and Minerals Development and Regulation Act 1957.
Yes.
Now, power of state government to make rules in respect of mine and minerals. The state government may, by notification in the official gazette, make rules for regulating the grant of quarry leases, mining leases, or other mineral concessions in respect of minor minerals and the purpose of connected therewith. In particular, without prejudice to generality of the foregoing power, such rules may provide for all or any of the following matters, namely. Then, Lordship, kindly come to 3. I am 1A, I am skipping, 2 I am skipping, I am coming to 3 directly. The holder of mining lease or any other mineral concession granted under any rule made under subsection 1 shall pay royalty or dead rent, whichever is more in respect of minor minerals removed or consumed by him or by his agent, manager, employee, contractor, sublessee at the rate prescribed for the time being in the rules framed by the government in respect of minor minerals. So this says the holder of a mining lease, I am a holder of a mining lease, or any other mineral concession granted under any rule made under subsection 1 shall pay royalty or dead rent, whichever is more, in respect of the minor minerals removed or consumed by him or by his agent, manager, employee, contractor, sublessee at the rate prescribed for the time being in the rules framed by the state government. Now, Lordship, it says that mining lease or any other mineral concession granted under any rule made under subsection 1. Now, subsection 1 says that state government may, by notification in official gazette, make rules for regulating the grant of quarry leases. Now, here the quarry leases was granted in my favor. Now, that was granted, there was a ceiling which was mentioned. Now, these particular clause of section 15, it talks about the holder of the mining lease. I am a holder of the mining lease. It cannot be said that it's a case of illegal mining. It's a case where I am the holder of the mining lease. The allegation against me is that I was exceeding the limit given in the stock. Therefore, Lordship, the rule is that it has to be first marked that this is the excess storage you have made. So this is a rules related to storage will come into operation.
Deals with the normal
Ordinary
mining
law.
operation. It
With-
doesn't deal with the excess storage.
Now, this will come only the storage rule, which I will come to that. The excess storage, how it would be dealt with. Now, Lordship, there are two rules which I found made by this state. One is the West Bengal Minerals Prevention of Illegal Mining, Transportation and Storage Rules 2002 and West Bengal Sand Mining, Transportation, Storage and Sale Rules 2021. Now, Lordship, I will come to the 2002 rules, which was not repealed. The West Bengal Minerals Prevention of Illegal Mining, Transportation and Storage Rules 2022. My case is that till I store till the maximum limit given under the lease agreement, it is legal. Excess storage may be considered to be the power exceeded by me. Now, Lordship, that's why this West Bengal Minerals Prevention Illegal Mining Transportation Rules will be applicable here.
Do you have a copy of the rules?
Yes, my lord. Lordship, may I read and then Lordship. Now it says illegal mining means mining activity done in violation of Section 4 of Mines and Minerals Development Regulations Act 1957 beyond the agreement. Now this rule, particularly Rule 6 says storage of minerals. Holder of mining lease quarry permit shall inform the authorized officer about the location where he would be like to store their minerals. The details of such location shall be submitted at least 15 days prior to the commencement of the mining operation by the lessee permit holder. 2. The lessee permit holder shall maintain proper stock of storage of minerals in the stores so indicated. The register should indicate inter alia the capacity of store, area of store, actual stock of minerals held category wise, daily status of entry of minerals in the stores, daily status of exit the minerals from the stores, daily opening of the closing balances. The lessee permit holder shall also maintain bin card in respect of each mineral kept in the store. An authorized officer of the state may at any time visit the stores and inspect the minerals kept in the stores with reference to the entries maintained in the register's bin card. The lessee permit holder shall allow the authorized officer to make inspections of minerals kept in those stores. So that was done in my case. Any obstruction to the inspection shall be treated as the obstruction to the duties of the public servant and shall be subject to penal action. After inspecting checking materials, the authorized officer shall record the visit inspection on the relevant pages of the stock register. 7. The authorized officer shall have the power to seize any mineral, the record of which is not found in the stock register. A seizure list will be prepared by him, and copy thereof shall be given to the lessee permit holder of stores in charge of appropriate acknowledgement. Notwithstanding anything contained in the Code of Criminal Procedure, the offence under the rule shall be cognizable. Any mineral seized under sub-rule 7 shall be liable to be confiscated by an order of the court competent to take cognizance of the offence shall be disposed of in accordance with the directions of the said
So
court.
how does it deal with
Now,
excess?
this deals with excess, because kindly come here, it says the authority, the lessee, once I am a leaseholder, I am stocking I'm maintaining the store of minerals. Now they have a right to inspect. They come to my store, they have inspected. Upon inspection, they have found that my store has more than minerals which is exceeding the limit in the agreement. They write it, and then they have the power to seize that particular minerals. Once it is seized by them, then the sub-rule 7 comes into operation. It says authorized officers shall have the power to seize any mineral, the record of which is not found in the stock register. A seizure list will be prepared by him. Copy thereof shall be given to the lessee, permit holder of stores in charge with appropriate acknowledgement. Notwithstanding anything contained in the Code of Criminal Procedure 1973, an offence under this rule shall be cognizable. Any mineral seized under sub-rule 7 above shall be liable to be confiscated by any order of the court competent to take cognizance of the offence shall be disposed of in accordance with the directions of the said court. On the last occasion, your lordship was inquiring from me that where the power of release is there, because earlier the rule which was cited by the respondents, that was the rule related to West Bengal sand mining, transportation, storage and sales rules 2021. Now, these particular rules, kindly, this rule also provides the power to search, then power to evict trespassers, power to enter, power to seize. Now, here, lordship, there I said that minerals, the word mineral is there. Now, under the West Bengal sand mining, transportation, storage and sales rules 2021, it says that whenever any person carries out sand mining operations or causes to be carried out any sand mining operations without any lawful authority, and for the purpose uses tool, equipment, carrier, such and such. This deals with completely illegal mining. My case is not the illegal mining. My case is the excess storage. This is a case for illegal mining. There they are empowered to seize the equipments, machines, and other articles or things which has been described as the property. There it is followed by the auction in case these properties are not, if they are not disposed of properly. Now, the only rule 5 says the same property is seized more than one time. Rule, it may be released on payment of at least 50% of showroom value of the property. Now, that is different. In my case, lordship, it has to be released from the competent court. Now, lordship, the question comes, under which authority they have done it? Under which authority they have decided to send these minerals for auction. Even the auction is permitted, that is permitted for the machineries or any other equipment which are seized. But for minerals, under which rules these auction can be done? Then they refers possibly the subject to correction, obviously, by Mr. Bandopadhyay, that is there the auction rules which is there. Kindly come to the auction rules. They have relied on the auction rules.
Yes.
West Bengal minor minerals auction rules. Now, what is auctionable? Now, auction for grant of mining lease. If I want a grant of mining lease, which I am already provided with, bidding parameters, bidding process, everything is there. Auction for grant of composite license. That is another. Composite license for district magistrate may initiate the auction process for grant of composite license. This rule does not deal with the auction of the seized articles. Now, kindly come to these rules. The auction for seized articles, what I found, seized minerals rather, I found apart from the storage rules of 2002, we did not find anything. And 2021 rules, it only adds the power to sell. Sale of those equipments, machineries and others, not the minerals. That power is not added in 2020, that 21 rules. Now, therefore, Lordship, I beseech your Lordship.
Auction rules say this is for auction of mining lease.
Mining lease, not for the minerals.
Not for the extraction.
Not for the extractions. For extractions, I was, Lordship, when your Lordship inquired me, I was searching these provisions, whether we have a power to release. That is as per section 100 of the CRPC. It has to be done. There is no other procedure to do it. Because something is seized, now whether it has to be released in favor of me upon payment of royalty or dead rent, anything. Now, dead rent can be paid or royalty can be paid. Whichever is greater, state will get that. That is the rule which I found. Now, Lordship, kindly come to their report once. This supplementary brief history of the connections on the last occasion which was submitted. Report. Now, first, Lordship, kindly come to report filed in the form of affidavit by one Sribas HON'BLE Bhakto. Lordship, got it? Kindly come to the way they have come to this decision. There is a confusion, real confusion.
Yes.
I am Deputy Land and Land Reforms Officer, SRO. I presently posted such as I would appear in the. Now, Lordship, kindly come to paragraph 4. As per prevailing 4.1 rules, permission of stocking of sand is given every year. And likewise, this year, stock permission was granted in favor of Ma Sharoda Enterprise in Ausgram Block 2, Mouja Kurul. This lease had obtained permit. This lessee has obtained permit of offline mode on 21st April 2022 for the purpose of offline permit. The petitioner had given declaration that he intended to store this CFT sand. The monsoon stock permit module was introduced in May 2022 and he has got permission to online portal. On closure of mining operations, I'm reading 2. On 26/6/2022, owing to monsoon onset, as is the practice, the stocks were measured and it was noticed that some lessees with offline permit had made stock over above declaration limit. Now, how they detected? Some lessees. On closure of mining operation on 26/6/2022, owing to monsoon onset, this is practice, the stocks were measured and it was noticed that some lessees with offline permit had made stock over above declaration limit. This was despite the fact that the online permits had mentioned that lessee cannot stack sand more than declaration limit without further permission. As the mining plan mentions, the yearly mining limit, that is the sand that can be mined for a particular year from the ecological environmental point of view, that limit cannot be exceeded as decided by the district committee of the competitive bidding. Thus, it was decided in the DCCB meeting that those who stored sand above mining plan limit citing declaration for offline permit will be imposed with penalty above royalty. Now, this penalty, the rule of penalty is the creature of a meeting, not a creature of a statute. This is not an outcome of a statutory exercise. It said, admittedly, thus it was decided in DCCB meeting
So this
that
was what was asked for from the state on the earlier occasion.
earlier occasion.
To put forward the rules.
That rules they have not. They already said that they don't have any rules
The
apart
state,
from this.
Submit whether,
Yes, ma'am.
because these points have been mentioned
Yes.
on the earlier occasion. They allege excess storage
And another thing,
and they want to auction.
and earlier also they have,
Seizure of excess excavation is permitted.
yes.
Now, let the state show where the rules.
And I
have
will
been-
only mention that on earlier occasion, they had released the excess storage in my case
They have released.
earlier upon payment of royalty, which is in page annexure P7 of the writ petition.
That's the prayer of your writ petition.
Lordship?
That was done during pendency of the writ petition.
No, earlier. Previously, this petitioner was prosecuted for this.
This is a second instance.
This is, Lordship, this is second incident
excess
in
storage.
respect of other lease. Other mining lease.
Other mining.
Mining lease. Earlier it was released.
Oh, so that matter is not under consideration here. That
I
is
am
in second.
I'm referring it, they have done it earlier.
You have filed the documents for it.
I have filed the document in the writ petition itself.
And you are ready to pay the excess.
I'm ready to pay that. If it is calculated in accordance with law.
Mr. Bandyopadhyay? The provision for auction. The provision for auction.
Provision manner that has been manner state by you. It has been carried to the prayer of the. December 2022.
Mr. Bandyopadhyay, you wanted to come back to show that there is a provision for auction.
If they are agreed with the order passed by the district magistrate ADM and DLRO, there is a provision of whatever may be the order, my lord, they may prefer appeal. Their grievance is this. They are, my lord, it is the submission of Mr. Chattopadhyay that they are the permit holder, my lord, they have granted this. It's a very mind. But they have stopped in excess of the permission. That has been, my lord, without permission, and that has been, my lord, seized, and it has been put into the auction. They have challenged the auction. Your lordship was pleased to participate in the auction process. If they are, once thereafter, but before that, my lord, they have moved their petition before the Honorable Court, and your lordship has guided the ADM and DLRO, hear the matter, and process is resolved. Accordingly, the hearing has been concluded, and my lord, after that, this will order has been passed. If they are agreed with the order, then they can prepare appeal under section 51.
51 is the concession rules. So is this order passed under the concession rules? How is it passed under the concession rules? Please come to the order.
As per provision of the 2016. Paragraph 2 of the writ petition on 28 February 2018, an agreement was made as well as the ADM and DLRO approval to estimate for 5 years for granting lease of minerals such and such. Therefore, there is a provision of appeal is adequate for the appellate officer.
Rule 51. Yes, Mr. Chattopadhyay, how do you respond to this? This is an order passed by the state authority.
Yes, I'm coming to that. Lordship, on the last occasion, I have referred to several judgments on this point. I said an order which cannot be permitted, which cannot be passed by any authority, if the order itself is void ab initio, whether this order can be appealed against. I have already referred to this judgment that Embassy Property Development Private Limited 2020-13, as well as
15 you said, isn't it?
2014 also I have given. Now, why there cannot be any appeal in this particular case? Because my learned senior friend has referred to possibly 51 of the concession rules, right?
Yes.
Now, I do not find any rule 51 in the concession rules.
There is.
The West Bengal Minor Minerals Concession Rule 2016. Kindly see. Report to the
Chapter 11. Chapter 11 of the rules.
On West Bengal Minerals Concession Rules, right?
Minor minerals concession rules.
Lordship, yes,
2016.
Lordship. Any person approved by the district authority and any officer duly authorized the district authority exercise of the powers conferred upon him by these rules may within 30 days from the date the memorandum of appeal. Each memorandum of appeal shall be completed. Now, what are the order to be passed by them? Has there been any imposition of penalty?
This is a provision for appeal.
Yes. When can it be?
Any
When-
order passed under the rules.
Not any order, Lordship. It says that any person agreed by an order made by the district authority or officer duly authorized by the district authority
Yes.
exercise of the powers conferred upon him by these rules.
These rules.
Now they have to show that the power has been exercised to.
The lease was granted under these rules. And the power is connected to with the lease.
Power is connected to the lease in respect of exercise of the powers conferred upon him by these rules.
Yes, so it is
Now,
these rules.
this auction is not permitted under these rules.
Auction is with regard to the lease.
They say,
It's connected.
It's
not an independent consideration.
now, Lordship, these auction
Is violation of the lease. That is
they
according to
say,
them.
according to them, they have ordered for the auction on the basis of the DCCB meeting, the decision taken in DCCB meeting, admittedly they say. They do not say this is an order passed under these concession rules.
A meeting cannot deal with
That's-
such an issue.
Lordship, that's why I say, kindly come to that
Has
order
its
once.
roots to the rules.
They have no, that's why this order has no root to these particular rules. That is the consideration. That's why I'm before this court. Why I'm asking so? Kindly come to challenge করেছি আমরা এটা তো impugned order. Lordship, kindly come to the impugned order once. The last paragraph. Now, as the sand stored in above declaration permission limit, the same will be disposed of according to memo dated 12/8/2022. They have not acted by in exercise of the power under this concession rules. They have exercised the power conferred upon them by this particular memo. Secretary, Department of Industries and Commerce, wherein it has been stated that in case of any stock found without any permission, the same is to be seized and auctioned following the due process as prevailing rules.
The order starts from 8th December 2022. It emanates from the rules.
Lordship, kindly come.
Whereas as per prevailing rules, permission of stock. So that's this
No.
rules.
They never say that. Kindly come.
Prevailing rules.
They say prevailing rule. The rule does not permit them to auction. They themselves admits that it is done on the basis of a direction of the department.
I think appeal lies.
Now that's why I referred to that, this judgment, Lordship.
This
once.
judgment is not really applicable here. I
Kindly
have
come.
seen the judgment. You refer to paragraph 15 onwards, isn't it?
Lordship, kindly come to paragraph number 19. Though the decision of the official trustee preceded meeting and can proudly be claimed as the Indian precursor to an English legal landmark, several subsequent decisions of this court considered in anisminic alone to have provided the breakthrough in Mafatlal Industries Limited versus Union of India, provided Paripuranam justice provided that the list of Indian cases cited, then 5 cases have been cited, but in ML Sethi versus R.C. Kapoor made certain interesting observations about anismenic. The learned judge observed that the effect of the dicta of anismenic is to reduce difference between jurisdictional error and error of law within jurisdiction. So I said there is a distinction between jurisdictional error and error of law within jurisdiction. So this is a jurisdictional error. It is not the error of law within jurisdiction. If it was an error of law within the jurisdiction made by them while exercising the power conferred under this rule, then Lordship, I would have been out of the court at the very beginning because the order is applicable. But here I said that kindly come there within jurisdiction, almost the vanishing point, and that came to.
Yes, so there is almost no distinction.
There is kindly come to the
And
next.
this is only an interpretation of the judgment.
Then
It's not an observation.
no, I'm coming to that. The observation I'm coming. Come to paragraph 24. Therefore, in so far of the exercise of the power conferred by Article 226, despite the availability of a statutory alternative remedy, is concerned in anismity cannot be relied upon. The distinction between lack of jurisdiction and wrongful exercise of the available jurors should certainly be taken into account by the High Court when Article 226 is sought to be invoked, bypassing statutory alternative remedy provided by this special statute. On the basis of the principle, let us now see whether the case of the state of Karnataka fell under the category 1, lack of jurisdiction on the part of NCLT to issue the direction of relation in the matter of MMDR Act 1957 and statutory rules issued thereunder, or 2, more wrongful exercise of recognized jurisdiction, say for instance asking a wrong question or applying a wrong test or granting a wrong relief. Now that is something which I am challenging. So the Supreme Court said in paragraph 24 of this particular judgment, embassy property, the so far question of exercise of the power conferred by Article 226, despite availability of the statutory alternative remedy, is concerned, anismety cannot be relied upon. The distinction between lack of jurisdiction and the wrongful exercise of the available jurisdiction should certainly be taken into consideration by the High Court.
So you're harping on lack of jurisdiction.
I say that lack of jurisdiction. They do not have the jurisdiction to pass this order. Admittedly, they did not exercise the power under these concession rules. They say that in case of the stock, they are going to apply the DCCB meeting's decision. That is why I am before your lordship. I say, I beseech your lordship, direct them to act in accordance with the law provided under the earlier rules, that is 2002 rules, which is not repealed.
2 rule doesn't cover auction.
Oh, that's why.
Just read out.
That's why that is the rule to be followed. In case of excess storage, that is the rule to be followed.
Have you served a copy of this judgment to Mr. Bandapati so that he can deal with it? Yes. There is a subtle distinction between jurisdictional error and lack of jurisdiction in it.
It is the outcome of the stock. Stock is lease. We are not in that. The lease, mining lease is legal now. It has been granted. But their case is this: without permission, they have stopped more than the excess limit. That is the excess.
They are ready to pay penalty.
That is the outcome of the lease. And this order has been passed.
The auction is challenged. The order of auction is challenged.
That is bad, my lord.
Whether
I think that it is bad.
Let them calculate the penalty, I will pay.
It is
Whatever.
Whatever the order which has been passed by the
so
ADMPL,
if it is not
there
in
is a
law,
function appeal.
you admit that no. If it is lack of jurisdiction, the writ court can deal with it.
But there is no lack of jurisdiction. It is the
This is-
outcome of the lease.
The authority has no jurisdiction
Then
to
how
pass
it
an
will
order
be
of
disposed
auction
of, my lord? I am asking myself.
on merits. This writ petition is maintainable.
No, it
Please
is
show
not
me the
maintainable.
jurisdiction. petition.
But they are my lord come before this honorable to make a seal from this honorable court to regularize the excess sand by making penalty. There is no provision for.
But please show me if there is no provision for auction. He is not agreed with he is not agreed with the Caesar at all. He is agreed with the auction order.
My lord is bad. Your lordship may set aside the auction. Your lordship, there is no provision challenge, my lord. They have not regularized that there is no prayer. Their prayer is only to set aside the auction notice. Your lordship state the auction notice. Your lordship may set aside the auction notice and take decision afresh.
Take decision afresh. What fresh decision can be taken on this?
There is no such provision.
Sand will damage. Last one.
You may prefer appeal. Where is the power? You may go before the appellate authority and agitate your grievances.
Some process is unauthorized.
That is unauthorized. That is. Any order passed by the
Any order within jurisdiction, Mr. Bandhavadar, the Supreme Court judgment is very clear.
The outcome of the lease.
Maybe, but if it is beyond jurisdiction, the writ court can intervene.
Your lordship may take fresh decision. Your lordship may set aside the auction.
That is exactly.
In respect of this case, in respect of this particular case, your lordship may set aside the auction.
So you are agreeing to the fact that the writ court can deal with the matter.
Fresh decision pursuant to the last law.
Fresh decision on what?
To regularize the excess amount. They are trying to take an order from the Supreme Court.
You have a representation pending.
Lordship.
You have a representation pending.
No, representations are disposed of, Lordship, by your Lordship's order. That is disposed of. Now, Lordship will.
For representation in this case also,
Representation to
page 31.
Page 31. Informing seize and auction of the sand which is totally wrong and baseless, and such sand notice should be washed. Immediately I have given the representation.
Representation 48.
And last representation is in page 48.
Will that help you at this stage?
No, it's not pending. It's disposed of because your lordships have directed them to, because under this petition we have challenged their
Only the auction part.
rescind order.
So
So that is the only part from, because they said it has been seized.
you have in fact challenged the auction notice.
Auction notice, that's so.
Not the reason order.
Not the, no, here in this petition, rescind order is challenged.
The auction notice. Please come to the prayer.
Because it was rejected and immediately the auction notice was same day.
The 8th December auction notice has been challenged.
Yes,
in-
and this was, and decision was on 8 December,
Same day.
same date.
I was not given any scope to file representation.
So let the auction notice be set aside.
Auction notice be set aside.
That serves your purpose because the
Okay.
remaining part you have to deal with the.
Yes,
authority.
according to law, lordship, then I can get it
Yes.
released.
So shall I record your submission, Mr. Bandhavadar? That you have not been able to show any provision for issuance of auction notice.
2016, except that.
Auction notice, you have not been able to show anything. Heard learned counsels for the parties. At the outset, learned counsel for the respondents
Lordship, may I take your lordship's leave?
challenge the maintainability of the writ petition on the ground that the order impugned is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules 2016. Paragraph in reply, comma, learned counsel for paragraph. Learned counsel for the petitioner places reliance on the authority in embassy property, Embassy Property Developments Private Limited versus State of Karnataka and others. Reported in 2020 bracketed 13 Supreme Court cases 308. Stop. Learned Counsel submits that since the petitioner has pleaded lack of jurisdiction on the part of the authority to issue the auction notice, comma, the matter can be dealt with by this court under Article 226 of the Constitution of India. Paragraph. The challenge in the writ petition is the notice of auction issued on 8th December 2022. Stop. Learned Counsel for the respondents has failed to apprise this court as to under what provision such notice was issued or whether any such provision exists at all, any such provision for issuance of any such provision for auction of excavation of sand by the lessee exists at all. Stop. In fact, comma, no such provision has been put forward by learned counsel before the court. Stop. Since the concerned authority had no jurisdiction under the law to issue such notice upon the petitioner, comma, it can very well be held that the order suffers from lack of jurisdiction. Stop. Therefore, judicial review of the said order and in exercise of jurisdiction under Article 226 of the Constitution of India is permissible. Paragraph. On merits, comma, since the notice of auction issued on 8th December 2022 is not supported by any provision entitling the authority to issue such notice, comma, such notice, comma, the notice impugned is held to be dehoves the statute and is liable to be set aside / quashed. Paragraph. In view of the above, the notice impugned, the notice of auction dated 8th December 2022 is set aside / quashed. The writ petition is accordingly disposed of. Chatelain.
Lordship, petitioner is at liberty to take the due course of law.
You have done that already, isn't it?
No, I have not, it is seized, but after that, Lordship, I have not, because no cognizance has been taken by the learned.
The auction part goes, you can deal with the authority with regard to the excess storage of sand. You are
Yes,
asked for that liberty.
yes, I'm liberty because as per this rule, Lordship. Kindly consider this 2000 rule, 2002 rules. This is the storage of minerals. There is a rules.
Pasha.
Stop.
Rule. This is rule 6.
Yes, this is 2002 rules. And then I will show your Lordship, this rule has not been repealed. That I'll show. Lordship, can you consider it? And then I'll This has not been reported.
This step has to be taken by the authority and not the petitioner for confiscation.
Confiscation, because I have to get it released. Then once auction goes, then seizure also then goes, Lordship.
Court cannot pass further orders in this court
It
case.
has to be there.
You have to file a further application before the authority. Because it is
Liberty may be given, Lordship, I will do that.
true,
To get it released once, according to law.
no, that gives the,
Yes, it was.
that gives you that concession, that cannot be granted.
No, because auction was after seizure, then
Third writ petition is only with regard to setting aside of the auction notice.
auction.
That has been done.
That has
No
been
further prayer is also there in the writ petition. So you have the liberty.
automatic.
You can deal with the authority. This court will not grant you liberty. in this case.
Also automatically that
Because it is for the authority to confiscate, you have to face the consequences,
consequences, and as per the
the criminal law, whatever.
that should be mentioned. CGMC.
The writ court will not give you such liberty.
Auction notice দিয়ে CGM করে দাও।
Next,
Lordship, it should be followed by confiscation, at least, Lordship, that may be.
why will the court direct? Let
Well,
the
let
authority
him-
deal with it.
Let them do it, otherwise nothing is there. Auction notice এর মধ্যে seizure.
That is exactly what I said. It's for the respondents to
Lordship.
pick up the matter now.
Grateful, my lord.
28. Yes. Report in the form of affidavit. National Highways, the state is filing a report today. Have you received a copy? You seek to use an exception? Or not? Is it not necessary?
Necessary because the state.
You want to come back with an exception? A report in the form of affidavit submitted on behalf of the state respondents is taken on on behalf of the state respondents, and exception used by the petitioner to the report in the form of affidavit filed by the National Highways Authority of India are taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report in the form of affidavit submitted on behalf of the state respondents this day. Paragraph, your contention will be different, Mr. Mukherjee, in the other exception. Have you gone through the report of the state? You need to come back with a separate exception for this. Very good.
The land for development of the highway. My land was sold as a highway land to the highway. Now, I have alleged the proceeding under section 50 of the LRR 1991, where it shows this land has been recorded in favor of the petition. So where this land, after the land is acquired, part of the compensation has been paid. So for the other the details of the reports the resident. Now this report filed by the person now considered the entire the section 50 proceeding as well as notification of the national highway authority. Where it shows that my land is a right land and right.
Very well. Come back with the exception. Let the matter appear under the same heading on 11 July, and please serve advance copies. 11 July. '29. State. Please switch on the microphone.
Your Lordship had directed by the last order dated 24th April to the state to come back with instructions. Your Lordship had said that it can be easily disposed of with the help of direction.
Service upon the state is complete?
Yes.
Oh, it's only the KMDA. Not the state. It's only the
The state
KMDA.
authority, yes. Your
Yes. Please switch on your microphone, Mr. Talukdar.
The instruction I have received, my lord may.
The KMDA has asked for some time to consider your prayers.
Lordship, is there any time frame mentioned?
No, I will do that.
Yes, Your
Court will
Lordship.
do
Kindly,
that.
Your Lordship would kindly.
Do you have a representation pending?
There
For
is
the KMDA,
uses
yes.
Your prayer twofold.
Yes.
That's
Let-
recorded.
let-
Have you stated this before the authority?
No, Your Lordship. We had sent them a letter.
So will you file a comprehensive representation?
Yes, that's,
I'll record the instructions of the authority.
yes.
That will help you.
That will solve the problem.
File a consolidated, a comprehensive representation before the authority. Let them deal with it within a stipulated time frame.
Yes, Your Lordship.
My lord will take on record this.
Yes,
instruction.
yes. Instructions submitted on behalf of the KMDA is taken on record. Paragraph. The instructions demonstrate that the prayer made by the petitioners has been under consideration with the authority, and the authority has sought some time to consider and dispose of the said prayer upon giving opportunity of hearing to the petitioners. Paragraph, in view of the above, in view of the undertaking given by the respondent authority, comma, the writ petition is disposed of.
Instead of recording undertaking,
I have recorded this, not
It's
your
not-
submission.
kindly as
This is an
instruction,
undertaking.
as instruction, not undertaking.
Your Lordship, if I may indicate at least one.
Be allowed to consider is an undertaking. I'm not recording your submission. I'm recording only this.
Yes.
If I may indicate just one thing, Your Lordship.
Or assurance, my lord may.
Undertaking
the
for assurance. He needs
I
a
may
change
indi-
of language. Yes.
If I may indicate just one thing, Your Lordship, as far as the second lot which is on the ground floor is concerned, there they have not considered it at all, and we are ready to give a representation. But as far as the other,
Please go through this once. You'll be able to. That's
I'm-
also stated.
Yes.
Which I will put in the
why I say so, Your Lordship, is because we have already paid the money.
Give it back.
Yes, sir.
It will be clear to you. You know. Record it after. The first paragraph.
Yes,
Yes. That covers
very,
both
very
the
well.
issues.
Yes.
That covers both the issues. The writ petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the who should be
Third respondent,
third
third respondent,
Before the
because here
third
deputy
respondent.
secretary is not made a
within 7
party.
days? Yes, within 7 days you can
7 days, yes.
file your representation within 7 days.
Yes, Your Lordship.
Within 7 days from date. Stop. The third respondent is directed to consider and dispose of the representation within 1 month or a shorter time.
No. Let it be.
Within 1 month from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of, Richard.
So my lord, in place of undertaking assurance. No much of that.
Mr. Talukdar is worried about the
Yes.
coinage, the term. Next.
Much obliged. Your Lordship.
30.
Observed respondents. Also, the petitioners are the sole owner.
My lord, in this matter, my lord, I want to raise the maintainability issue, my lord. না, এটা যশোর না বললে আমি কি করব?
Now, the petitioners are the owners in respect of.
Mr. Mukherjee, since maintainability issue has been raised, she'll have the first right of all.
Grateful, my lord. My lord, as your lordships knows, when there is any inspection, after the inspection, lordship, we have only found there is any encroachment, lordship. We sent a notice under section 26, subsection 2. And in this notice, my lord, we covered all the land details and the plot numbers, all have been mentioned. After that, lordship, we have asked them to appear or to give any representations, and then, lordship, we passed our recent order, my lord. In this case, my lord, my learned friend is aggrieved with this recent order, my lord. If your lordship kindly come, this recent order, my lord, that is page 115, my lord.
115.
115, my lord. That is the, my lord, as per my learned friend, this is the impugned order, my lord. He's praying for setting aside this impugned order. My lord, got it, my lord?
Yes.
My lord, in this case, my lord, to the name of the notices with schedule of the property, lordship. In this case, lordship, side by side, the plot number has been mentioned. And lordship, kindly see all unauthorized occupiers of land located in, kindly allow me, lordship, kindly allow me. All unauthorized occupiers of land located in Mousa, lordship, that has been mentioned, Maheshwarpur, jail number 160, PS Datpur, district Hooghly, my lord. This writ petition has been filed under this district Hooghly, my lord. My lord, this recent order has been passed by the highway administrator, project director, Kolkata, my lord. And now, lordship, kindly come page 66 onwards, my lord. My lord, kindly come page 66 onwards, up to page 88, my lord.
These are the notices.
My lord, this notice, lordship, kindly see, lordship, the first National Highways Authority of India, PIU, my lord, the project implementation unit, Durgapur, my lord. Totally a different project, my lord. We are issued the notice under the project director, project implementation unit, Kolkata. It's totally a different unit. And this is, lordship, the Durgapur. Lordship, kindly see the notice, lordship. See the plot number, my lord. Entire plot, lordship, is 831 and 832, which has no connections with this recent order, my lord. Lordship, kindly, lordship, again, lordship, kindly come this plot number. This 115, my lord. In these plot numbers, my lord, nowhere mentioned this 831 and 832. Lordship, because this recent order, this plot is totally different, is issued by the project director, Kolkata. And what my learned friend is annexed in this, lordship, that is a Durgapur, issued in another matters, lordship. And this writ petition has been drafted, lordship, on the basis of this plot number 831, 832. And this recent order, lordship, what my learned friend is praying for setting aside, has no connections with this notice, my lord.
That is on merit, lordship. This cannot be.
How, lordship, this is on merit, my lord. It is a ground of maintainability. This is a defective writ petition.
It is a ground of
maintenance.
It is a defective writ petition.
This is on merit. Also, I will prove this case. But lordship, maintainability of the writ petition, this cannot be a.
My lord, entire writ petition, lordship, lordship, kindly see his prayer, lordship. His prayer is setting aside this recent order. His prayer is setting aside this recent order.
On the basis of this misleading, lordship.
Kindly see, this is misleading, my lord. This is misleading.
This writ petition under article.
My lord, kindly see the entire page 66 onwards, my lord. How, lordship, the project implementation unit, Kolkata, will do with this notice, my lord.
Your prayer is for setting aside
The reason not.
the notice of eviction issued by the concerned authority on 13.
My lord, that is 101, my lord. That is paid, that is our notice.
Ground for maintainability. Writ petition can be maintainable. But
Okay, where is the notice of 13th?
My lord, 101, my lord. If I am not mistaken, lordship,
This is
101, my lord. Page 101.
What is going to the merit of this case? Then this is my turn.
Your prayer should be in conformity with the documents,
That's why I will prove
even
this.
without going into merits.
Lordship, I have.
My lord, Durgapur, this project lordship is in the Durgapur, and this recent order issued by the Kolkata project director, Kolkata.
That this on this ground.
My lord, this is a defective writ petitions.
WPA 23, reference number 23246.
I don't know, Lordship, I failed to understand how this
Please,
is.
please,
can
let
be
me
accounted
just
for
check. Please let me check. Yes, the page 101 notice has been challenged.
Yes, my lord.
So that is-
Only this lordship and other,
Kolkata.
yes, my lord, that is Kolkata. Well, other the lordship kindly see, entire petition has been drafted on plot number 831 and 66 onwards up to page 88, my lord, kindly see. This notice has been annexed, were issued by the Durgapur PIU, Project Implementation Unit Durgapur, my lord. That is a totally different case, my lord. He totally clapped this matter in one writ petition. This is totally misjoinder of parties, my lord. My lord, see this recent order, who is asking for setting aside. These are the 22 encroachers.
This is jail number 60, LR DAG number 402.
Yes, my lord, that is.
Fifth round of litigation, my.
Mr. Mukherjee, in the notice that you have challenged, 13th September 2022, the plot numbers are 592, 593. Yes, your writ petition says 831, 832.
831, 832.
Paragraph
May I start initially?
My lord, this first plot is this.
Clarify.
Yes,
Let him clarify. Without going into merits, please clarify this issue first.
Lordship, these notices were issued in the year 2015.
You have not challenged these notices.
No, I'm coming after. 2015, these notices were issued that the petitioners are occupying this plot 831 and 832. This is the land of the National High Authority. There should be removed.
Yes.
I have challenged this notice initially to 2016.
In an earlier writ petition.
Earlier,
Very well.
fifth county.
Very well. Then
Now, in this writ petition, this Honorable High Court directed to demarcate the land because our case was we are occupying plot number 402, which is the land of the Jela Police. So all orders have annexed. Now, Lordship, after that, they again issued one after another notice without demarcating. I again come before this Honorable Court. This court again directed to first demarcate the land, then initiate the proceeding of the eviction.
that is a different plot.
This 831, 832, always. Now, Lordship, ultimately, after several 2-3 writ petitions, the writ petition came before your Lordships. Your Lordships set aside the earlier notice and again directed to demarcate the land and to consider the objection of the petition. Now, in terms of your Lordship's directions, Lordship, they have issued the notice and the reason order. Now, in the reason order, they have shown that this is the plots number. On this plot number you are occupying, you have to be evicted.
Here the plot number is not 835 and 831 and 832.
This is their case.
My lord, the documents reveal so, my lord. The documents
This
reveal
is
so.
their case that you are occupying this, but Lordship, our case is we are occupying 402. Now, Lordship, first of all, my case is
Where does 831, 832 come?
according to 831, according to their notice, they are showing that we are occupying 831, 832.
But you are not occupying 831, 832.
All these notices have been issued to the petitioners. All the petitioners have been issued.
So if you are not occupying 831, 832, why are you before this court?
Yes. They are going to.
Yes.
They are going to physically evict me.
From 831, 832, you are not there at all.
The Lordship, I am also praying. Lordship, let them restrain them from not evicting 831, 832. That our
You are not occupying 831, 832.
certainly
at
not.
all.
I'm looking 402 of the
So,
Jela
and
Police
there
Act.
is no notice of eviction on 402.
No.
So what is your difficulty? Why have you come before this court?
So that's why, let's say, I'm praying.
Let there be any eviction drive on 831, 832, you are not affected?
No, certainly no.
So what is your difficulty? Why are you before this court?
Because Lordship, they are showing we are occupying 831, 832 XYZ.
If you are not occupying, remain silent. Whoever is occupying will be evicted.
That is the because
So why have you come? What is you? How is your right infringed?
Kindly restrain them from evicting us from plot number 402. That is my purpose, sir.
That is not your prayer at all.
Lordship, that is not his prayer.
And that
Lordship,
is not the
this is-
notice of also.
Lordship, that's why, Lordship, kindly allow me to open my case from the beginning.
How do you explain these differences?
Lordship,
Your petition says 831, 832.
Lordship, let me kindly come.
You
page
have
66.
asked for SLing the notice on at page 101. That relates to
Lordship,
592.
kindly come page 66 first.
Please come to 101. This is the notice that is SL'd in the writ petition. There is some confusion, Mr. Mukherjee. Please clarify that.
Lordship, before that, Lordship, kindly your Lordship's order at page 9900. Kindly come page 97 first. Your Lordship's order.
Yes.
This is the how can the repetition cannot be maintainable after fifth round of litigation?
Page 98.
My lord, this is lordship's order.
97. Page 97.
Yes.
Lordship, Simon Sir, who usually appears for the state is present in the court is requested to present.
98 is the order.
Now, in the matter is the appointment, the petitioner should serve the copy now on request. Kindly come. This is not ready, right? Kindly come page 98. By an order to the 27th July 2018, in WP number 11,312 W of 2018, the coordinates of this court recorded that the National Highway Authority of India sought NHAI decided to demarcate the concerned land in presence of the state authorities and the petitioner. In the event of such demarcation, it was found that the petitioners were encroaching upon the land belonging to the NHAI. Press notice would be served upon the petitioner, and only after hearing them, a final decision could be taken to removal of encroachment of according to law. In compliance with the said order, demarcation of plot number 402. Also, kindly consider this. Demarcation of plot number 402. I am reading page 98. Second paragraph. Plot number 402 was made by the revenue officer along with the revenue inspector and army in presence of the NHAI. The joint inquiry report submitted on 14th of June 22 clearly indicates that such inquiry was not done. In presence of the petitioner as such, the direction of the coordinate page has not been complied with. Now, in view of the same, the respondent are directed to conduct a fresh joint inquiry in presence of the petitioner in terms of the order of the coordinate page passed on 20th July 2018. The present petition challenges the notices under 26(2) of the Control of National Highways Act 2002. Issued up to the petitioner for removal of the unauthorized construction. The said notice plot number 831, 832, whereas it is submitted on behalf of the NHAI that the subject matter of plot is 402. And also the coordinate page of this court directed service of press notice upon the petitioner. In the event of an encroachment by them, after the inquiry and demarcation of the plot in question was done by the authorities in presence of the petitioner. In view of the same, the notice dated notice under section 26(2) of this Act 2002, dated 20th May 2015, having no hearing of the plot in dispute set aside and quashed. The writ petition is disposed of. Now, Lordship, kindly come. This is the notice has been issued.
So page 66 onwards, notices have been set aside.
Set aside.
They are no longer there.
Yes. Now, Lordship, they have issued a notice for joint inspection as per your Lordship direction. Kindly come page 101. Now, Lordship, 102 is our letter to withdraw the impute notice. What ground, Lordship, I have stated. On removal, I'm just reading page 103 for removal wherein direction has been made unauthorized structure construction in respect of plot number 592, 593. Expected a plot, at area 618-540 RAHA under Moja Mohestar jail number such and such under section 26(6) of the control of such and such act. Which is absolutely contrary to the stolen order passed by the Honorable High Court. Now they are saying we are encroaching the different plots. From time to time, several litigations which are initiated.
This notice, Mr. Mukherjee, is on one of the petitioners. Rafiqul Islam, Safiqul Islam.
Serial number 15.
Safiqul Islam is one of the petitioners. It has been issued on him saying that he is encroaching upon 592, 593.
Now let's say plot number is changed.
Because Lordship, the project director is still Lordship. That is a different place. That is Durgapur. That is Kolkata. That is different.
Kolkata. No.
Only Kolkata, Lordship.
Set aside. Durgapur is no longer in the scenario.
Lordship.
It is set aside.
No. I mean,
The impugn
Now the plot
notice,
numbers have been changed.
impugn notice is on one person. So why, number one, why so many petitioners have been tagged?
Now kindly come. This is our objection that we are not encroaching even this plot number 590, 593.
Impugn notice is on one person. Why
Impugn
objection
notice
by all the
1%.
petitioners?
But Lordship, this was Lordship according to them, this notice has been issued to all. Now Lordship, kindly come.
No, it has not been issued to all. It has been issued.
this is
only to
totally
one
wrong
person.
submissions. Totally wrong submissions.
Therefore, you, Safiqul Islam, it is stated in the notice. Please, Ms. Ron. Yes. It is only to one petitioner.
This notice, which is served to the, I have annexed one to one notice.
So it is a misjoinder of parties.
My grateful, my lord.
Lordship, this notice has been issued only one of the petitioner. I have annexed on to one notice.
You should have annexed all the
Lordship,
notices.
these notices have been issued to all because the reason,
No.
Lordship, because the reason order reflects that this reason order pertains to the grievance of all petitioners. Kindly come page 115. Lordship, I have not annexed all the these notices, but the reason order reflects that 22%. This reason order is against this 22 persons has been passed, indicating different plot numbers. Lordship, kindly consider the stand of the National Highway Authority.
My lord, may I submit one thing, my lord? May I submit one thing, my lord?
Madam,
না আপনি বলছেন আমি একটু না আমিও জানি না কি করব বলুন স্যার
Lordship, this Rafiqul Islam's notice has been served. Lordship, that kindly come the page 114, Rafiqul and some one person was Lordship. But the reason order has been passed against 22 persons.
Yes, but you say your plot number is
402.
402.
Lordship, my only contention, let there get demarcation that we are occupying 402, but 402, Lordship, this petitioner on physical verification, Lordship, did not residing with the 402. Where is that, Lordship? Lordship, to that effect, the physical measurement report, even your Lordship directed in one order, Lordship, I have annexed that in presence of the concerned block land and land rules officer, this measurement was directed to be conducted. Now, Lordship, kindly come page 116, last paragraph. No, is it a reason order? Is it a notice? Kindly come from the reading and from the first line I am reading, page 116. A notice of the subsection of section 26. This is the notice of the control of National Highway Land and Traffic Act 2002 was served upon 22 unauthorized occupiers of highway land and Moja such and such Hooghly. Since some of the unauthorized occupiers of the land resisted to receive the same notice was also struck on their encroachment. In terms of the said notice were given to remove the unauthorized occupiers within 7 days from the date of receiving the notice. Submit their representation in 3 days. It may be representation was to be placed in hearing on 26 September 22 at the project director such and such. In pursuance to the notice, two members, Ramkrishna and Rokikul of the unauthorized person, appeared in the hearing on 26 September 22 and have submitted a written representation signed by Bhagavato Das, unauthorized occupiers, the same are dead, dead as under. There is only mention in the plot number 402, which was related to the inquiry of communication number such and such, but they did not produce any supporting document of claim of their ownership of the plots. So here in this clause, the kindly see 402 is the land of the Jela Porishad. I have managed the records. From 2015, we are uttering the same thing. The 2402 is the land of the Jela Porishad. National High Authority has no authority to issue this notice under this control act.
Notice is not in respect of 402. The notice has not been issued in respect of 402.
Our we are occupying and running our shop.
In 402, but in 402, no notice of eviction is there.
No notice.
So you are not under threat of eviction.
Now my case here in this repetition that they are issuing the notice of different plots, but they are trying to evict us because the evict us. On the contrary, we are occupying 402.
Will you continue some other day?
And also this notice, this is a reason order as well as notice.
Service. Heard learned counsels for the parties. That the matter appear under the same heading for further consideration on 11 July.
So in the meantime, let there be a status quo.
No, my lord.
Because
No, my lord.
see, I have
You are occupying a land which is not covered by the notice at all. There is no question. Now in this writ petition, no protection can be granted in respect of 402 because that is not your case at all.
now,
You are challenging an order which deals with some other plots, not 402. And admittedly, you are not occupying those plots. You are in possession of
But
402.
also kindly one that effect that the National Highway Authority has no authority to evict the petitioner if they are occupying 402. Also only to that
The
extent.
authority has not been
Also,
trying to
this is
execute.
the case. Also, now
My lord, this is on the basis of the assumption.
Come back.
My lord, my lord.
402 is not subject matter of the writ petition at all. So no order can be passed in
No,
respect
I
of
am
402.
2015, I am continuing the writ petition one after another saying that we are occupying 402. So also kindly to that effect, the petitioner shall not be evicted from 402. To that effect.
402 is not the subject matter at all.
No, so this is my prayer because
Come back. And there is no threat of eviction also in 402.
this is state of eviction. Also,
Lordship, before answering, Lordship, item 32 minute.
I have not
Because-
called, sir.
No. Tomorrow, this is my personal difficulty. My son-in-law admitted in the Nightingale. Operation date is tomorrow. Lordship, take it at Monday, fixed.
If it is called, please ask someone to make a move for an adjournment. I'll go.
One indulgence, my lord, item number 21, my lord. My lord.
Thank you. Call for the-
One.
This, one the contempt.
Please serve and come back.
Only one thing, my lord. Whether it's required to be served again, when your lordship kindly see the, my lord, page 20, my lord's order. It's order, na?
Yes, this has.
But
not
the
been
second paragraph. Now, your lordship, thereafter, your lordship, the page 21, your lordship specifically directed. The para starts, the writ petition is accordingly disposed of. Then your lordship said that this, in the light of the observation made there. They passed an order. After this passed an order, your lordship kindly see this importance. Yes, that is at page 25. Now, the
Yes.
1, 2, 3, 4. Yes. This apparently it may appear that no tax is due in respect of so and so under cover this so and so, but the said tax is for ordinary service, whereas the instant permit on the interstate route Purulia to Hazaribagh is of express service. Hence, balance stroke additional in respect of the vehicle number so and so is due and is paid to the permit holder. Now, your lordship kindly sees your lordship's observation is that this is in respect of road tax and additional tax. The lordship will find that page 20, the prima facie appears that no tax or additional tax in respect of that. But the annexures therein in respect of road tax and the additional tax.
Say that it has not been complied with. So please serve and come back. Since it's a contempt application, you need to
Your
serve.
lordship, in original side, normally your lordship, the rule has to be issued first. If your lordship finds that this has been, they have taken this, they considered and seat on the appeal of my lord's order.
Upon
They
hearing the
seat on
alleged
the
contempt,
appeal of my lord's order. This is
upon
only.
hearing the alleged contempt, no, not before that, isn't it?
This is they seat upon the my lord's order in an appeal. An administrative authority sitting in appeal.
Serve and come back, I'll consider. The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 6th July. You can serve by then?
6 July, I will not here.
Oh, you'll not
6
here.
and 7.
So next is 13th July. 13th, 1, 3.
Item number 2, item 2, my lord, I am.
There is an incident.
Yes.
I beg to appear for the state. I am assisted by Mr. Mondal.
Your lordship's direction was to file and accept such report. That report has been filed. It is retained with the record. With respect to the report filed, my lord, I have filed an exception that your lordship will also find in the report.
Have you served a copy of the exception?
My lord, yes.
Yes,
Copy has been
yes.
exchanged by the parties.
Yes, what is the matter of?
Now, my lord, the case made out by the petitioner is that despite the property belonging to me, the state is illegally retaining possession of my property. When number of times representations were made, they claimed that under 2 notifications, they have acquired the property and it is with them. I wrote to them that provide those 2 notifications in the writ applications mentioned, which you have stated in your letters. They didn't provide me those 2 letters, which they instructed that under this they have acquired. Lord, the writ application was filed and your lordship, my lord, directed them to file a report. The report also does not contain their own statement made in the letter relating to the fact that by dint of these two notifications, the property was acquired. For that, my lord, if your lordship may kindly turn to the report filed by them.
Yes.
The reporter.
This is under the Estates Acquisition Act. So this court will not have jurisdiction.
My lord, this is
under the Estates Acquisition Act.
my lord. Actually, my point is that they have not acquired it under any recognized process of law. They say that it has been acquired. Now the basis of acquisition is silent in the writ application and the correspondences available in writ application.
They have referred to a section 4 notification under the Estates Acquisition Act.
State Acquisition Act. They say in the report that under State Acquisition Act, the property was acquired. Now the essential requisites for a property to be acquired under State Acquisition Act is not fulfilled, nor it stands satisfied.
So this forum cannot deal with the with that.
State Acquisition Act, my lord, doesn't go before Land Tenancy Tribunal Act.
It is a specified act.
My lord, I will have to.
Yes, it is.
My lord, I understand, my lord, not.
It
I
is a
kindly
specified.
check it. My lord. Land Reforms Act, the Land Reforms Act, Land Reforms Act,
Land Reforms and Tenancy
Land
Tribunal Act.
Reforms, আছে?
Land Reforms and Tenancy Tribunal Act.
Mobile phone, Land Reforms Act.
কিছুই করবে না, assistance বসে থাকা।
Because the writ application, when I filed,
আমি তো তাই
they
জানি।
say that the property was acquired under Land Acquisition Act. The moment your lordship directed them to file a report, they are silent about acquisition under land.
You have the book?
That has got it.
No, it is not here.
এটা দিন না।
Land Reforms and Tenancy Tribunal. And it is specified act.
Section 2R,
Yes.
মানে on the left hand side, my lord.
You've seen the statutes of like that. এটা ওনাকে একবার দেখান তো।
Land reform আনা উচিত ছিল না, land
ওনাকে একবার দেখান।
বলেছিলাম তো বইটা নিয়ে আসো, Land Reforms Act টা।
So without wasting further time, why don't you approach the appropriate forum?
My lord,
Without wasting further time, why don't you approach the appropriate forum? I'll grant you liberty
my lord, your lordship
and
may,
delay will be condoned.
my lord, your lordship may kindly take it next week, my lord, because I will examine whether the dispute can be tried by the Land Reforms Tribunal or
That
not.
is not the question here.
No.
The question is that it cannot be tried by this court.
No, if it cannot,
Who can try it is irrelevant at the
if-
moment.
If it cannot be tried, then, my lord, I will have to invoke under this act before the Land Tribunal. But the point is, my lord, the point with which I came before the writ application, they say that this is acquired under, my lord, Land Acquisition Act. The moment report was called for,
Yes.
the moment report was called for, they failed to show that in the writ application, there are reference of 2 letters issued by the state government. They say by this date and this date, this was acquired. Now in the report, that is totally absent. They have come up with another plea that it was acquired under State Acquisition Act. Now there are 3 multifarious acts and correspondences by state itself. If they can show prima facie that this has been acquired under this act, my remedy will be there.
You want to wait for another week?
1 week, my lord, 1 week. Let it be taken up. Next week I will examine. তোমাকে ল্যান্ড রিফর্মস একটা আনতে বলেছিলাম, এটা আমাদের বই নয়।
ওনাকে তো দিয়ে দিন।
On prayer of the petitioner, the matter is
Acha,
adjourned. Let
madam.
the matter appear under the same heading. Come back on 6th July.
Yes, my lord, I will come.
6th July.
Because the cause of action with which I came now stands changed. But those records of these states are material,
But-
and these are on writ application
But
itself.
even then.
Therefore,
I
they
think,
cannot choose in
the
their
other
whims.
forum can be, please come back.
According to their whims, they cannot change those correspondences.
Please come back.
Grateful, my lord.
It has never acquired. it was vested
Here later.
under West Bengal estate acquisition.
You refer to a section for notification.
Item number 3.
Wait for time.
Opposing.
Order sheet.
I'll tell you, Lordship, this has happened a couple of times.
Order sheet. Order sheet.
I will be constrained to show some of the orders that the Honorable Division Bench has passed and has expressed its hope that these two writ petitions will be now disposed of, because the corporation has not done anything. They came up with the first writ, which was, I took that point of demurrer, then they amended it, and with that amendment, it's just been languishing because that has been kept pending. My writ petition has not been taken up.
Well, on the earlier occasion, it was by consent of the parties that it was adjourned.
But that was probably because it was a day before the vacation. And we did not want to waste your Lordship's time on such a heavy
It was on
motion.
11th May. What
That's
the
it.
reasons may be,
Yes.
but then prior to that, it was on prayer of the writ petitioner. So please do not raise vehement objection today. Come back on maybe 6th July. Will it be all right? 6th
But
July.
allows us to come back next week.
Next week may be a holiday, isn't it?
Next week.
9th maybe Eid.
No,
The calendar
next
says
week
so.
is the
The
22nd.
High Court has not declared.
22nd. May I just? No, they just want to delay it because they want the contempt to go. Kindly have a look at this order. Your Lordship's officer has been handed it over.
Well, will you come back next week, 22nd?
The Lordship, as far as the state is concerned, I'm not sure whether.
Yes.
There has been a change in the panel and the parcel
I've
was
heard
there, he's no more there. So kindly, this is one more week's time. That's it.
No,
You need to serve
22nd.
afresh, actually.
Look, I
Why
shall
don't you
serve.
serve afresh in the meantime.
I'll serve tomorrow itself. Keeps it on the 22nd. State is not the answering respondent. It's the corporation versus me.
Serve and come back.
I'll serve tomorrow. Lordship, giving them a week. In all matters, the state is appearing. I have not heard the submission that they're taking an adjournment because.
I have granted several adjournments. on
Oh.
this one because it depends, because in some of the cases, the panel lawyers have been shifted. They are not there anymore. So you have to serve.
But I'll
afresh.
tell you, Lordship, what the predicament is. The matter is again fixed on 21st of June, the contempt. They are not allowing the contempt to be taken up, showing the pendence of the writ. And the writ, they're allowing it to be pending without actually doing the matter even once. Keeps it on 21st itself, the matter is there before the learned division, before the Honorable Division Bench.
Prior to that, we don't have a Thursday.
So Lordship keeps on the
So let's
21st. At least we'll be able to say that the contempt should not be.
But 21st is not the original side day.
No, I'm saying next 22nd. I'm sorry.
Come back to 22nd.
22nd.
22nd. Both the matters are being taken up together.
Yes, yes. Ma'am.
On prayer of the, he is appearing for the corporation.
Yes.
Corporation.
On prayer of the corporation, the matter is Kolkata Municipal Corporation. The matter is adjourned. Let the matter appear under the same heading on 22nd June 2023. Paragraph, this court is informed that Mr. Nobu Kumar Dash was appearing. He is no longer in the panel. Mr. Nobu Kumar Dash, who represented the state in this matter, is no longer in the state panel of lawyers. Paragraph, in view of the above, the petitioners are directed to serve the state afresh and file affidavit of service on the adjourned date.
The 22nd is a Tuesday, man. 22nd is Tuesday.
No. 22nd is a Thursday.
Next.
Next Thursday.
But could I just pray for one observation? That on that day, no further adjournment will be granted. I'll be able to use that.
Taking turns in taking adjournments, sir. I cannot make such an observation now.
We have not taken adjournments. No.
Yes, last it was by consent. Before that, it was your.
The writ petitioner. Their writ petition. I have not taken. Every day I come and clamor for a hearing to be taken up because my contempt is going to go.
Please serve in the meantime.
But I'll be able to use that order. Very well.
Please serve the state in the meantime. And file your affidavit of service on the adjourned date. Otherwise, it cannot be
But
taken.
that is my concern. They'll come and say that the corporation has not been able to serve on the state.
petitioner.
I am the writ petitioner.
Serve in the second matter, that will serve our purpose.
Yes, yes.
Serve the opposite.
I will serve both.
One of the matters it is served, the other matter automatically comes.
I'll
in.
serve both. To be on the safer side, I'll
Wait,
serve both.
wait. Come back next first.
Fine.
No, alagad, separate orders, কিন্তু same order.
Item number 4.
Same order.
Both same.
Item number 4, same
Oh,
order.
acha.
In item number 4, it is not Mr. Nobukumar Das. There was another advocate, Mr. Domingo Gomes.
He is
So,
also not in the
He's
panel.
also not there.
So let the same order be passed.
But the name has to be different.
নামটা switch করি, yes. ফাইলটা দেখে নেন, ফাইল দেখে নামটা বের করুন। না, দরকার নেই। Hearing তো হয়নি তো।